Good morning. Welcome to the Law and Mental Health Conference. Our subject is civil commitment. I'm Jason Renaud. I'm the coordinator of the conference, and I've been coordinating the conference since 2000 for the Mental Health Association of Portland. Now, in the past 3 years, we've been in this new format, online and digital, available for viewing at any time. Before we get started, a bit of housekeeping. The conference this year will have 2 live keynote sessions with Dr. Appelbaum on the 7th and Dr. Vinson on the 8th. Both live keynotes will have, immediately afterwards, we'll have Q&A sessions that are live where you'll be able to ask questions of the doctors via email or via the chat function in the YouTube channel. We will read your questions live back to the doctors and get answers directly. So be sure to have, as you're watching, formulate questions and put them in the chat. At the end of each day, the session speakers throughout the day are invited to come to a live panel session where you will be able to ask questions of the panelists. And there'll be some discourse between them as well. But I think we've had a lively discussion in past years. I'm looking forward to it this year. We'll have that at the end of the day, both on the 7th and on the 8th, with the available session speakers on both days. You can, again, ask questions of either the keynote Q&A or for the panel session via email or through the chat function in the YouTube channel. Now, note, you do not need to watch the conference in real time unless you want to participate in these live sessions. You can watch it at any time you want, day or night. Of course, it'll be available to you through these YouTube links in the program and available throughout the month of November. If you need to access the conference after November, you'll have to message me and we'll send you an individual link for that. But the conference will fully close in November. Continuing education credit for people who have assigned for the National Association of Social Workers, those people will get a certificate of completion that has a code for the Oregon NASW. They share that around the country. You can submit that to your licensing agency in your state. If you're a member of law enforcement, we have a form in the program for you to use to fill out and to send to your public training center in your state. If you are a member of the Bar Association and you've indicated that in your registration, we will send you a certificate of completion designated for the Oregon Bar Association, and that should be transferable to any bar association around the nation. Finally, if you are a peer worker or addiction services worker licensed here in the state of Oregon, we will be giving out credit through the Mental Health Addiction Certification Board of Oregon. We call it MACBO, and we'll send a certificate, a message to them that you have been a participant in the conference. Now, last, I'd like to thank the session presenters. I've seen a few of these. They're really interesting. I think you're going to have a lot of fun watching them and learn a lot. And so thank you so much for both our keynoters and session presenters. And then thanks also to our sponsors. We have about 175 people who have come to this conference by scholarship that is paid for through sponsorship. And so great thanks to those persons. You see them in the program. We have about 100 people who have identified themselves as either students or people with lived experience, and about 75 people who got the public defender discount. So really good welcome to those folks for attending the program. So thanks for your attention. That's the end of housekeeping. Let's get on with the show.
Hello to everybody at the Law and Mental Health Conference. It's Congressman Jamie Raskin coming to you from Maryland's beautiful 8th Congressional District. Thank you for an opportunity just to say hello to our keynote speakers, Dr. Paula Appelbaum from Columbia University and Dr. Sarah Vinson, who is a child and adolescent and adult psychiatrist from Atlanta, Georgia, working with the Morehouse School of Medicine. Hello to both of you. Hello to all of the participants in this really important and significant conference. I know that your subject this year is civil commitment, which raises all kinds of profound problems. about people's freedom, people's dignity, people's right to due process, at the same time that it calls on all of us to take seriously the problems of different mental illnesses and the fact that people are not always in control of their faculties and their senses. And my son Tommy used to tell a funny story about a professor of philosophy at Columbia named Sidney Morgenbesser, who, as the story goes, and it may be apocryphal, was there when Dr. Thomas Szasz came to appear before the faculty and made his argument, as of course the crusading anti-psychiatry academic, that everything that was in the DSM was just a reflection of social and cultural pathologies and anxieties. And he did this very long lecture, and then he finished up and he said, and therefore we can say really that mental illness does not exist as an objective fact in the world, but it's just a projection of various social and cultural the anxieties and difficulties with different forms of behavior. And Sidney Morgenbesser raised his hand at the end of it and he said, thank you very much, Dr. Szasz, for coming. Do you mean to say that this whole mental illness thing is basically in our heads? I always liked this story, and Tommy told it better than I could. But it does show some skepticism about the idea that there's really not a problem with mental illness, that the problem is all with society. I assume that all of you as practitioners don't agree with that idea and understand we're dealing with something real, something very painful, something very difficult, a real hardship for people who are experiencing it. So we have to balance our interest in people's civil liberties and their freedom and their rights to due process and to respect for their decisions with the fact that mental illness is a real thing that people labor under and struggle with. And so that's why we need all of the best professors and all of the best doctors and researchers to put their heads together to figure out solutions both for mental illness and for the thorny problem of civil commitment. I look forward to the results of your conference and wish you all best luck.
Hi, everybody. Good morning, and I'm pleased to be with you to talk to you a little bit about civil commitment and how we came to be where we are today. Let me share my slides here with you, and we'll dive right in, and I'm looking forward to your comments and questions afterwards. Okay. So what I want to do over the next half hour is to review with you the history of the law of civil commitment in this country. And the reason for doing that is not mere antiquarianism. It is because it's my view that in order to understand civil commitment law today, one has to understand the history of it. In essence, civil commitment law today resembles an archaeological site. There are many layers of law that have gone into it over the last century and a half, and they were all put there for a reason. And understanding that reason, I think, is essential to understanding how the law works and the ways in which sometimes the law doesn't work. We also want to talk with you a little bit about the effects of the most recent round of statutory reform that we've been through in this country. And then, to the extent that we have time, I will talk a little bit about the major innovation in civil commitment law over the last several decades, which is the move towards outpatient commitment, and both what that hopes to achieve and what its limitations have been. So just to give you a preview, I'm going to divide the historical period into 5 epochs, if you will, beginning with colonial times to the 1830s, what I call the pre-institutional period, of the 1830s to the end of the Civil War, the early institutional period, end of the Civil War to the Gilded Era to the mid-20th century, the period in the late mid-20th century when we had our most recent time of intensive statutory reform and litigation. And then you'll see how we ended up where we are today. So to begin where this country began, in colonial times, in the times of the colonies, there were, of course, no institutions, no hospitals. At the very beginning, not even jails or poorhouses at first. Where people with mental illness could be relegated or cared for. The mentally ill in the early colonial period were simply ignored, or in some places dealt with under the criminal laws, and as they developed later on, the poor laws, which is to say they were arrested for vagrancy, begging, minor disturbances of the peace, and jailed for short periods of time once jails were established. The New England colonies had an interesting system which they called warning out. That is, it was a mechanism for getting rid of outsiders who might appear in their town and who were considered undesirable to be there. They would be marched to the border of the town and warned out, that is, told never to come back. And then they'd be in the next town, and they would be that town's responsibility, and perhaps would undergo the same warning out process there, and then again and again. It's a ship of fools kind of story, wandering from port to port and never being able to establish a secure residence anywhere. As jails and almshouses were built, as the colonies matured, they began to fill with people with mental illnesses. There was nowhere else for them to go. There were no other institutions dedicated to their care. The earliest hospital in the colonies is not established until 1751, so it's almost a century and a half after the first colonial settlement in Virginia. We see the first hospital established, that's in Philadelphia, the Pennsylvania Hospital, which exists until this day. And the second patient admitted to the Pennsylvania Hospital in 1752 was, in fact, a person with mental illness. When the successors to the Pennsylvania Hospital in Massachusetts and New York and other colonies began to develop in the early states, they were dealt with in the same way all other patients were dealt with, which is to say, as far as the early hospitals were concerned, there was really no such thing as a voluntary hospitalization. Patients were generally not brought to a hospital for any purpose unless they were quite severely ill. and they were usually brought by their family. The family would approach the hospital, ask for admission, if needed, pay in advance for a particular period of care. And when the money ran out or the patient was ready to leave, the patient would be discharged. So the patient was not terribly active in this process. It was negotiated around the patient, typically by their family members. There were no statutes that governed the hospitalization of people with mental illness or any other patients for that matter. States were not involved at all as we moved from the colonial period through the Revolution and into the early years of this country. And until the 1830s, which is to say, for more than 200 years after this nation was founded, that was the system of caring for people with mental illness. They could be jailed. They might be put in almshouses where they were supported, but often required to work for their room and board. They might be hospitalized in one of the few hospitals that existed, but all this went on outside of any legal process. Things begin to change in the 1830s, and the drivers of that change are a group of reformers in New England, the most prominent of whom was a woman named Dorothea Dix, a school teacher, Sunday school teacher, who began visiting inmates in the local jail. She lived in Cambridge. She went to the Middlesex County Jail and was there to teach them about religion. But she was stunned to see how many of them were there essentially because they were mentally ill. And she wondered if the Middlesex County Jail was unusual in some way. And so she started visiting other jails in the state and almshouses in the state and found that a huge proportion of inmates of both were people with mental illness. She then gathered around her a group of reformers who were interested in addressing this issue. They had the strong belief that jails and almshouses were not the right place for people with mental illness. And they petitioned the legislature to build a state asylum, as they were called back then. The first hospital in the state specifically for the treatment of people with mental illness. Now, it wasn't the first designated psychiatric hospital in this country. That hospital was built in Virginia, in fact, in Williamsburg, Virginia, what later became Eastern State Hospital. And if you go to the Williamsburg recreation today, you will see a recreation of that original building with some exhibits dedicated to the early treatment of people with mental illness. But in 1833, Worcester State Hospital opens in Massachusetts, and it becomes the model for state hospitals for many years to come. This was an era of what has been called therapeutic optimism and moral care. That is, these reformers believed not just that they could provide a more humane environment if they took people with mental illness out of jails and almshouses, but that they could actually provide a more therapeutic environment, that taking them out to the country, which is where these hospitals were generally built, and treating them in a way that gave them some self-confidence, allowing them to work. The men worked on the farms that surrounded the hospitals. The women did sewing and embroidering and other kinds of interior tasks, that would lead them to reconstitute themselves and be able to be discharged, cured. And the first commitment statutes are enacted in this era, beginning in the 1830s and continuing in the 1840s and 50s. and they essentially codify the existing practices, which is to say that they embody the notion that either family members or, for indigents, overseers of the poor, would bring the patient to the hospital, that the physician in charge or his designee would determine that it was appropriate for the person to be hospitalized, and they would be hospitalized and kept as long as that was necessary. But the patient played no role in that process. Moreover, the signature of the admitting physician was adequate legal warrant for their confinement. The courts were not initially involved at all. That set of procedures essentially continues until after the Civil War, which marks the start of a period of increasing dissatisfaction with the state hospitals. The dissatisfaction comes from the fact that they were beginning to fill up with more patients than had been envisioned initially. And legislatures were beginning to balk at providing adequate resources, adequate funding for a continued high level of moral treatment. They begin to feel a little bit more like warehouses than they do like facilities for active therapy. And the quality of care and the quality of life declines. And for the first time, we begin to see complaints about the abuse of the commitment process. The most famous of these comes from a woman in Illinois, the wife of a preacher, Elizabeth Packard, who was committed involuntarily by her husband, alleged that she was railroaded just to get her out of the way because she was inconvenient to him. And after her release, travels the country, writes a number of books about her experiences, and urges the first of the legal reforms of the commitment process. And her favored legal reform was a requirement for a jury trial. That is, she argued that before anybody was involuntarily committed, they should have a chance before a jury of their peers to establish that they actually did not need to be in the hospital. Along with jury trial, other reforms that are adopted in that period include a requirement for judicial review at some point early on in the commitment process, free communication with counsel and with political leaders and others. Another innovation of the period is the initiation of the process of voluntary admission. So for the first time in 1881, a state, Massachusetts was in the lead again, adopted a statutory provision that allowed patients to sign themselves into the hospital and to sign themselves out of the hospital, a true voluntary admission process. New York followed in 1882, and the idea caught on, although from that point through the 1960s, only a minority of patients who were in the hospitals were there voluntarily. The vast majority were still involuntarily committed. What's important to recognize in this first era of procedural reform is that as the procedures were being changed, the substantive criteria for involuntary commitment remained the same. And they were essentially that a person was mentally ill and in need of hospitalization or in need of care and treatment in a hospital. The language varied a bit from state to state, but the basic idea did not. Somebody judged that they were mentally ill and they needed to be hospitalized, and that was all that needed to be proven. From the 1890s into the mid 20th century, We saw an alternating series of reform cycles, which were driven by two conflicting sets of desiderata. When among the public, concern about access to treatment predominates, that is, when it was believed that it was just too hard to get people into a hospital, procedures were relaxed. And one example of that comes in the progressive era in the first decade of the 20th century, when we see the introduction for the first time of what we know today as two physician certificates. That is, physicians were allowed without judicial review, at least without prospective judicial review, to sign a form that authorized the involuntary hospitalization of somebody who was mentally ill and thought to be in need of hospitalization. But when concern about the rights of patients is foremost in the public's mind, when they're worried about exposés suggesting that patients are being railroaded into the hospitals, we see a tightening of procedures. For example, a requirement for judicial review of so-called warrants of apprehension before someone can go out and bring a patient in. It wasn't enough to have two physicians' signatures. A judge had to approve the process. And these considerations are in tension, both reflecting legitimate public concerns, but in opposite directions. Again, however, and then this is critical to keep in mind, the substantive criteria were unchanged. We're still talking about criteria that focus on need for care and treatment. The 1960s and the 1970s are the period during which our current system comes into place. So we are dealing with a system that is at minimum 50 years old, half a century old now, and has undergone relatively little change over the last half century. And in order to understand how we got the system we have right now, one has to recall what the 1960s and 1970s were like. It was a period when civil liberties had a new focus, of public attention. The Civil Rights Revolution that begins with Brown versus Board of Education in 1954 gives the courts new tools for protecting the rights of minority groups, which eventually come to include people with mental illnesses against the state. It was also a period when the legitimacy of institutions, all institutions, was being questioned, and that included psychiatric institutions. And the questioning didn't just come from former patients or critics of psychiatry. It came from within the profession as well, as community psychiatrists who had coalesced around a group of ideas that were first formulated during World War II in the Army Medical Corps, and then brought home after the war, argued that large state institutions where people were committed for long periods of time were actually detrimental. They led to institutionalization and a loss of functional capacities of patients, and that what we ought to have instead was a system of smaller community-based facilities, both inpatient but especially outpatient, where people could be treated rapidly in close contact with their home communities and families, and return to the community as quickly as possible. It was a period of general suspicion of the state and expertise in general. This was when Thomas Szasz published his famous Myth of Mental Illness, a book whose title was probably as influential as anything that was in the book. And it was a period in which the reality of mental illness itself was being questioned. Those questions were of intense interest to legislators who were concerned about what the mental health system was costing the state budget. The mental health budget was the Medicaid budget of its day, by which I mean, in most states, the largest single expenditure in the state budget was for the support of the state psychiatric hospitals. And it just kept going up every year. And legislators were desperate to get a handle on that and to find a way of reducing the cost. Put all that together and add to that the legal challenges that were brought against the existing generation of commitment laws. And you end up with fertile ground for a revolution. And the revolution initially was driven by the courts. As exemplified by Lessard v. Schmidt, a Wisconsin federal district court case in 1971, the courts, emboldened by the new powers that they had been given by the Supreme Court led by Earl Warren, began to strike down existing commitment statutes on two grounds. First, that they were overbroad, which is to say that by allowing anybody who was in need of treatment to be involuntarily hospitalized, they exceeded the legitimate bounds of state power, that the state had no right and no interest to confine people merely for their own good, that there had to be something more. And what that had to be was a danger to the public at large, or conceivably to the person themselves. The statutes were also struck down as unduly vague. It was argued that need for care and treatment in a hospital was a standard that amounted to whatever a psychiatrist said it was, and therefore was not easily susceptible to review by the courts, and hence was constitutionally deficient as well. Moreover, in addition to challenging the substantive standard for the first time, these cases challenged the adequacy of the procedures that attended involuntary hospitalization, especially to the extent that they deviated from the criminal procedural model. And so the courts, and Lessard again is a good example here, began to require a list of rights for patients who were people who were being subject to involuntary hospitalization, rights to notice, a right to be present at their hearing, a right to have an attorney represent them, a right to the rules of evidence being applied, including limitations on hearsay evidence, a right to appeal initial determinations, and a right to periodic review. So no longer could people be found to need hospitalization and then retained indefinitely without ever having a chance to contest that hospitalization in a court. As we said, the need for treatment standard, the historic standard, was replaced by the dangerousness criteria that I think you all know very well. The most, the strictest, most extreme, if you will, version of that appeared in the decision in Lessard, which required, prior to authorization of involuntary hospitalization, that there be an extreme likelihood that if the person is not confined, he will do immediate harm to himself or others. Dangerousness is, which is to say must be, based upon a finding of a recent overt act, attempt, or threat to do substantial harm to oneself or another. So note the language, an extreme likelihood of immediate harm as manifested by a recent overt act, attempt, or threat to do substantial harm to oneself or another. So you can see from a fairly loosely structured system with fairly vague criteria, we shifted to a much more stringent set of criteria, and one that very different from its antecedent, focused on dangerousness as opposed to need for treatment. A criminalized model of procedures was adopted, and for reasons of time, I won't go into those. But I do want to say something about what the consequences of these reforms were. These are reforms with which we live today, as any of you who are familiar with existing statutes are well aware. The explicit goal of the reformers was to limit the power of the state and to reduce the number of people who were being involuntarily committed. Civil libertarians thought that that was going to increase the rights of a group that was being treated as a disenfranchised minority. Legislators believed that it would reduce the expenditures for mental health care in the state budget. Community psychiatrists thought there'd be a more effective system of care that would be developed in the community as opposed to the hospital. If you look at the empirical literature that attempts to elucidate what the consequences of the reforms were, what you see is much less impact of these reforms than expected. There were decreases in the number of people who were committed, but those decreases seem to relate more to the concomitant process of deinstitutionalization, which was closing down state hospital beds. There was just nowhere to put these people, and so commitments just didn't take place. Moreover, studies that attempted to identify patients who were really in need of being hospitalized, but were not hospitalized because of the new stringent criteria, found that it was very difficult to identify such people, that most patients who really needed treatment were involuntarily hospitalized if they weren't willing to come in voluntarily. But there were, of course, large variations across jurisdictions that we can certainly talk about. However, there is a general perception that the laws made involuntary commitment more difficult to affect. What the laws did not particularly do, what the dangerousness-based approach does not particularly do, is resolve the ambiguity, one might say vagueness, of the statutory criteria. Alexander Brooks, one of the legal pioneers in this area, noted that dangerousness essentially had four components: the magnitude of the harm, the probability it would occur, how frequently it was likely to occur, and how imminent it was, and that sometimes these had to be traded off against each other. But in order to assess any of these four, much less to balance them against each other, the process resembled art more than it did science. We were still in the realm of having to make difficult judgments that were not easily susceptible to review. And that's where we are today. We have a very different system, but one that is clearly aimed at focusing on dangerousness, but no easier to implement than the old system was. I think I don't have time right now to get into outpatient commitment, although I'm happy to answer questions about that. But let me wrap up. To summarize, there's been a marked shift in legal rules over the last 50 years. We've moved to dangerousness style criteria and criminal style procedures. We have in some states adopted outpatient commitment as an alternative, And we've implemented more restrictive rules on involuntary treatment, which we can also talk about that if you like, even of committed patients. Where we are today represents a compromise between two important concerns, as commitment law always has. Between, on the one hand, a paternalistic desire to help people who are having a hard time in their lives, maybe in a great deal of distress and pain, and on the other hand, to respect their autonomous decisions, especially if they're deemed competent to make those decisions about whether or not they want to be treated. We may not agree among us as to whether the line today has been drawn in the right place, but we do need to recognize that there are important values on both sides of this debate. And any future reform is going to have to balance this set of conflicting considerations, although it may not necessarily balance them in the same way the current system does. So let me stop there. Let me stop sharing my screen, and I think we can move to your questions and comments.
Thanks, Dr. Appelbaum. That's a wonderful presentation, really comprehensive, and I appreciate your precise language. Thank you. We have a bunch of questions from that we got via email and in the chat, and we'll just proceed as we receive them. The first one is, were there civil commitment laws in other countries that helped shape law in the U.S.?
So, in the 19th century, most of the world had not yet developed commitment law in a formal statutory sense. And we were not, as a country, looking abroad for guidance. That we were very much inner-directed in terms of the development of our commitment laws. I will say that our reforms of the 1970s, and from the start of the 1970s to the end of that decade, every state in this country changed its commitment law. the pattern set by the United States has been very influential in other countries abroad. There are still countries that retain something like Britain, that retain something more like a need for care and treatment standard, but most of continental Europe and much of the rest of the world has moved to a dangerousness-based standard today as well.
Fascinating. We have a question about, it seems like every state's law is different. We're out here in Oregon and ours don't work. Do you have any opinion about state laws, state by state? Which ones are better? Which ones are worse?
So let me answer that in a general way, which is to say that when people are in a mental health crisis, the circumstances of their situations are so different one from another and so unique one from another, that statutes that try to embody an approach like the one in Lessard, with very strict, specific criteria, run the risk of excluding people who really need help from being helped during those crises. A certain degree of flexibility in the criteria, I think, is very important in allowing these statutes to do what they're supposed to do, which is to identify people who may hurt themselves or hurt other people and very much need hospitalization. So that's one way I would answer the question. As far as procedures are concerned, although procedures are more alike than unlike each other from state to state, there are some interesting differences. So in New York, for example, New York is the only state in which a court hearing does not take place as a matter of course after involuntary commitment. In fact, hearings are uncommon. Instead, every patient who's involuntarily committed is assigned an attorney at public expense who comes to meet with the person and tell them that they have a right to a hearing if they desire it. But most patients don't desire it. Most patients waive that right, believing that, maybe they don't want to be there, but they probably do need to be there, and they're not likely to win a hearing anyway. And they can always have a hearing if they desire it. And the courts have upheld that approach, which saves an enormous amount of resources, ferrying people back and forth to court all the time and involved in preparing and delivering testimony, and the adversarial environment in which hearings take place. So I think it's an example that suggests that sometimes we can be creative about how we protect people's rights, and we don't have to fall lockstep into alignment with a criminalized procedure model.
Yeah, it does seem that the criminal, it's supposed to be civil, but it really looks criminal. Court proceeding does seem to be a bit of a kangaroo court. That's interesting to hear about New York. Would you speak about, someone has a historical question about the practice, the misuse of civil commitment of husbands civilly committing wives, basically to get rid of them.
Yeah, so this was the allegation of Elizabeth Packard in the 1880s and 90s when she traveled the country. It is not clear, as I understand the historical research on this, exactly to what extent that was ever true. One could understand how a sort of urban or rural myth would grow up around it. But Gerald Grob, one of the leading historians of of the mental health system in the United States looked intensely into Mrs. Packard's case. She was claiming at the time of her involuntary hospitalization that she was a reincarnation of the Virgin Mary, which understandably would be embarrassing to a husband who was a minister, but also might well have reflected a degree of grandiose delusionality that could have been associated with bipolar disorder. So, was she railroaded, or was she really in need of treatment? Not an open and shut case.
So perhaps the stuff of Hollywood. And
yes, gaslighting is a potent meme, but exactly how often that sort of thing happens, I think, is much less clear.
Thanks. Would you speak of some states allow for the civil commitment of alcoholics and addicts? Tell us a little bit. That seems to be in opposition to the recovery model, but may be necessary in some chronic case. What's your thought on that? Yeah, so although there are a number of states that have statutes that permit involuntary hospitalization of people who have substance use disorders, there are really only 2 states in the country that use that law with any frequency. Those are Massachusetts and Florida. Interestingly, very different states politically and socially, but the 2 leading ones in terms of utilization. The systems are what probably the first thing to say is there are no good studies that tell us how effective this approach is in terms of getting people on the road to recovery, which is what their ostensible purpose is. They get people off the street. They may allow them to be held in a facility and to detox over a period of a couple of weeks to a month. But what has always been the bugaboo here is what sorts of services were available after they were discharged to allow them to continue on the path to recovery. And even the states that use this extensively have not built the kind of outpatient-oriented treatment system that would seem to be necessary for that purpose. So there may, in fact, be people whose lives would be saved by an acute intervention, but the system is nowhere well enough designed to allow broad-scale usage on the grounds that this is going to be the most effective way to intervene in a large number of cases. My friend Anne-Marie from Salem, she's in charge of all things crisis in Salem, Oregon, asks the question, do you see outpatient commitment as an effective alternative for persons who are not meeting the same high bar for dangerousness, but still need treatment and are not engaging well?
Yeah, so as you noted, I skipped over at the end for reasons of time the discussion of outpatient commitment. So let me say a couple of things now. Outpatient commitment was, I think, largely driven by what were perceived as the flaws in the revised commitment laws post 1980, and in particular, the problem of revolving door patients, people who would be hospitalized involuntarily, stabilize, take medications, be ready to return to the community, and then very quickly stop taking their medications and relapse and come back in. And people would go through that cycle many times a year in some cases. Outpatient commitment was proposed as the answer to the question, what can we do to break that cycle? How can we transfer to a situation of lesser constraint the kinds of treatments that are available in the hospital, but apply them in the community setting. And the data on outpatient commitment, although they are controversial for reasons we can talk about if people want to, are, to my eye, generally supportive of the notion that it can be effective if used for a long enough period of time. So the data suggests that for 6 months or less, it's really not very helpful. If you're able to stabilize people on outpatient commitment for more than 6 months, which usually means for a year, well, then you see lower rates of hospitalization, lower rates of homelessness, less substance use, lower rates of violence, and higher rates of continuing on medication. So it looks as though it is a potentially helpful intervention for people who otherwise were falling through the cracks. Probably not for everybody, because no intervention works for everybody, but at least for a substantial number of people. The problem with implementation in most places has been that although legislatures have been willing to pass these statutes, they haven't been willing to fund them. And the assumption has been that money would come from the existing mental health budget, which was, everywhere always overcommitted already, and that would somehow, be enough. Only New York, and I'm not speaking as a New York booster here, but just to be perfectly accurate, only New York appropriated several $100 million to create new services specifically for people who were being placed on what in New York is called assisted outpatient treatment, or AOT, and avoided just sending people out into a void. Unless we're willing to do that in other states, outpatient commitment is just not going to really make much difference.
But it would save funding money in the long run, as hospitalization would be addressed.
Yeah, you would certainly think that that it would, and it should. The other thing about outpatient commitment, which is very interesting, is that it tends to evoke strong reactions, negative reactions from civil libertarians and many patient advocates, because they see it as the transfer of coercion to the community. But what's interesting about that claim is that outpatient commitment is not a terribly coercive system anywhere in this country, by which I mean that although people are ordered to comply with the terms of their outpatient commitment, take medication, go to sessions, etc., if they fail to do so, no state allows them to be medicated involuntarily or to be compelled to go to sessions that they don't want to go to. The most any state does is provide provisions for people to be brought in for an evaluation to ascertain whether they meet involuntary commitment criteria. Well, if they met involuntary commitment criteria, they could be involuntarily committed whether they're an outpatient commitment or not. And if they don't meet those criteria, then they're simply released. So it is actually a remarkably non-coercive system, but it is one that tends to evoke very strong emotion.
Oh, you mentioned New York having funding. California has just an enormous, everything in California is an enormous amount of money for their new care court. Are you familiar? Could you comment a little bit on what California is doing?
Yeah, I was involved as a consultant early in that process when it had a somewhat different shape to it. But it seems to me what they've constructed is a system that provides an alternative, frankly, to the current inadequately functioning community mental health system, with an alternative route into it to allow people to receive care. It started out quite different. It started out conceptualized as something much more like an outpatient commitment system, which they already have an outpatient commitment statute, Laura's law, but one that carried more teeth. And that evoked so much opposition that they backed down and made these care courts into something that is really a voluntary process. People who don't want to participate don't have to participate in it. I'm hopeful that they will do some good evaluations so that we know whether this has really made a difference there or not. It does unfortunately reflect a tendency that we have to create new systems and layer them on top of existing systems rather than somehow fixing what's wrong with the existing systems. But that seems to be an intrinsic part of the U.S. political process.
Well, speaking of politics, then, many people believe that the mental health community is involved in a civil rights movement, and some see civil commitment and hospitalization as a form of systematic oppression, with the desire of some control these communities in the interest of maintaining structures of power. You've heard these arguments. What's your opinion here?
I think what those arguments ignore is the reality of human suffering. Mental illness is not just a deviant form of self-expression, as people in the 90s, some leading theorists in the 1960s argued that it was. People like R.D. Laing, or even Thomas Szasz himself, who was a psychiatrist. It is a disorder, an illness that can cause an extreme amount of suffering. It is painful to be psychotic. It is acutely painful to be depressed. Mania, notwithstanding the accompanying euphoria, is something that can cause a great deal of suffering, particularly as people come back down from their manic state and realize how they've blown up their lives. That reality, I think, tends to get lost in these politicized discussions of social control and suppression of individual expression, in which commitment law and the mental health system in general are often framed. As a psychiatrist, I can't ignore that individual level of suffering. And to me, when I go back historically, that always seems to me to be what the civil commitment process was about. The creation of facilities that were intended to be therapeutic and of statutes that would facilitate people who needed care but were unable to seek it for themselves being admitted to those facilities. We often did it badly. We certainly, from the Civil War on, never funded it adequately. But the notion, it seems to me, was inherently a good notion, that we ought to be there to alleviate people's suffering, particularly when they're not able to help themselves.
Thank you. Continuing in politics, but maybe from the other side, a question from the defense bar here attending is, how can attorneys and other advocates for people who are suffering advocate for outpatient commitment, or in some states, outpatient commitment laws at all?
So unfortunately, if you look at what the drivers have been of the adoption of outpatient commitment laws in many states, it's been a tragedy, a violent tragedy. Here in New York, our law is called Kendra's Law because Kendra Webdale was pushed under the wheels of a subway train. In California, it's Laura's Law, named after a woman who was killed by a person with mental illness. And the laws are adopted under the assumption that they will somehow prevent violence on the part of people with mental illness. To me, that's the wrong basis and the wrong way to think about these statutes. Violence by people with mental illness is an extremely small part of the very big problem with violence we have in this country. Outpatient commitment may not be the most effective way of dealing with it. Indeed, in New York, it was noted that Andrew Goldstein, the man who pushed Kendra Webdale under the subway car, had been seeking treatment and was turned away because there were inadequate facilities to provide treatment to him. So outpatient commitment would have been irrelevant in his case. I think the argument needs to be made on humanitarian grounds, that this is an effective way to help people who are caught in this cycle of continued relapse and recovery, but then followed by another cycle after that. But experience suggests that it's the other argument that actually tends to carry the day.
Well, in a sense, you've already answered this question, but I want to ask it again because you are familiar with Dr. Zeke Emanuel and perhaps his thoughts on returning to a state asylum model. What do you make of that? Where does that come from?
Well, ever since deinstitutionalization began in the 1950s, but really accelerated in the 1960s, there have been people who have lamented the demise of the large state hospitals that at their peak held over 500,000 people in this country. And it is in fact true that those facilities provided some services that many people with severe mental illness lack today. It gave them a place to sleep, not on the streets. It gave them 3 meals a day, which they may not always have. It kept them out of the clutches of drugs and alcohol, which are comorbid plagues for many of them. So it did good things, but at a cost in human terms of isolating them from the rest of the world and labeling them as different from the rest of us. That's the attraction of it, but I think also the harm of it. There are better ways, I think, to do that. If we adequately funded community systems of care and other support systems, the vast majority of people with even serious mental illness could be cared for in the community. Do we need more long-term beds? Yeah, in some states, I think we do, but a return to the old asylums is not the answer.
What do you see as the future of reform here for civil commitment? And what's the role for reformers?
So at this point in time, it seems to me whatever reforms take place are likely to be incremental, as they have been pretty much for the last 50 years. I don't see us overthrowing in a revolutionary decade like the 1970s, the dangerousness-based statutes. I think we can modify them to some extent to make them more flexible and more adaptable to the individual circumstances of people. We can get rid of requirements that may inhibit their use when they're necessary. But I don't think we're going to see big changes. Now, of course, revolutions are always difficult to predict, and something could happen tomorrow that would prove me wrong. But I don't, in the foreseeable future, it's hard for me to envision massive changes to our laws. I think we're going to see incremental changes.
We have a lot of advocates here who, in this conference, who are people with lived experience of mental illness, and they have a great desire to be part of reform. Do you have any words for those persons?
Yeah, I think they have an important role to play as we think about, and we should be thinking about what is good about our current statutory approach and what doesn't work in our current statutory approach, and how could we modify it to make it work better without incurring unreasonable costs in doing so. And people who've been through the process, it seems to me, have a unique perspective that needs to be at the table.
Thank you, Dr. Appelbaum. This has been really wonderful, very helpful. For folks watching, Dr. Appelbaum has been gracious to put his email address in our program if you have additional questions that he can specifically answer. Is that okay, Doctor?
That's fine. There may be limits, but I'm happy to hear from people.
Thank you. Thank you. We'll take a short break and be back with the next session in a few moments.
All right. Good morning, everyone. Very excited to participate in this amazing conference and to be able to present on an interesting topic. I hope for all of you. My name is Jonathan Cantarero. I currently serve as the director of the Legal Navigator program at La Cosecha Community Center out in Long Island, New York. And I'm here today to talk to you about the ethics of civil commitment. My own interest in the mental health field started way back in my college days, working in special education at a public high school, and then in law school, working with government and nonprofit organizations who represented individuals who were facing civil commitment, and also provided support services for individuals who had been civilly confined and were looking to reintegrate themselves back into the community. And so a lot of what I'll be talking about sort of reflects my experiences in those spaces. And, I just want to clarify, right from the beginning, what we're talking about today is understanding the ethics of involuntary civil commitment. So there's a distinction in all 50 states between voluntarily agreeing to go to a psychiatric institution and involuntary confinement that usually requires a petition from police officer, peace officer, judge, or perhaps a medical professional. I think that distinction is pretty important. Not too long ago, my community center served a family. There was a young lady who had been the victim of a crime, experienced trauma, and in discussing the crime with a medical treatment provider, had expressed that she wanted to hurt herself. And so the medical provider gave her two options. You can voluntarily agree to undergo a psychiatric watch, or we can petition to have you involuntarily confined for a few days for observation. And in that particular case, she agreed to voluntary commitment, but oftentimes, the decision isn't so black and white. And so I just want to make that distinction right from the beginning. So a little bit of a roadmap of what I want to talk about today. Three basic sections. I just wanted to outline for you a little bit of the history of civil commitment in the United States, then talk about the state's power, where they get their power to deprive someone of their liberty in this way. And then third, the real meat of this presentation is discussing the ethical foundation that allows the state to deprive someone of their liberty by civilly confining them in an institution. So very quickly, the history of civil confinement in the United States can be really broken up into three different sections. Early on in the 17th and 18th century, mental health really didn't exist as an independent field. Psychology and psychiatry were not discrete practice areas. There was no such thing as a psychiatric institution, an asylum, a mental ward, a psychiatric unit of a hospital. There was no treatment, right? There was no medical treatment. There were no prescription drugs. There was no outpatient. There was nothing. So even though there were clearly individuals who today we would be able to identify as someone suffering from a mental illness, there was really no support systems for them in place for decades. And so what ended up happening was one of two things. In some cases, the family dealt with the mental health issues of a particular family member, and they were essentially confined to the home. In other cases, maybe they didn't have any family members to support them. And, when they were in the public square, they would, demonstrate idiosyncratic behaviors. What would happen in those instances is they would just get locked up and thrown in jail. So you'll see, for example, in New York, there was a law in the books in 1788, which allowed for someone who was exhibiting lunacy or who had gone mad to be locked up in a jail and, if necessary, put in chains. So this is the situation that we had in the 17th and 18th centuries. Individuals who were mentally ill and exhibited some abnormal behavior that was threatening to others, they were either kept in the home or they were jailed. You fast forward into the 19th and the mid part of the 20th century, and things go in the completely opposite direction. You have advancements in medicine, you have growing public awareness, and so you see an explosion of psychiatric facilities opening up all across the country. And as more people are being civilly confined, more money is being pumped into these institutions, more of them are being constructed and erected. And you begin to see a large segment of the population being warehoused essentially in these psychiatric facilities. And I've seen this, in my own hometown growing up. I grew up in Brentwood, New York, where literally a section of our town was set aside for Pilgrim State Psychiatric Center, just acres and acres of land. It was almost a town into itself with its own railroad, its own bus stop, its own mechanic shop, because there were so many people being civilly confined in these centers. And you might say, well, it's not abnormal for there to be a large institution if it's the only one of its kind, but that wasn't the case. You walk down 15 minutes and you'll find Kings Park Psychiatric Center, which was just as big and housed just as many individuals. And so, as you can see, there was a bit of a roller coaster ride in terms of where individuals who were mentally ill and maybe exhibited other threatening behaviors, where they were placed. In the early part of this nation's history, they were either in the home or they went to jail. because the state, frankly, didn't know what to do with them. Later, in the 19th and mid-20th century, they were very easily put into psychiatric institutions. That was part of the problem, the lax civil commitment standards at the time. The third time period that's relevant here is what we might call the disability rights movement of the 60s and 70s, where there was that, again, a growing awareness that putting money into a system doesn't necessarily mean they're getting the best treatment possible, and that there were a large number of individuals who were civilly confined without any mechanism for assessing that they were receiving due process, either in the initial commitment proceeding or for periodic reviews to ensure that they weren't perpetually kept in a psychiatric facility. So to make a long story very short, what ended up happening is there were a series of Supreme Court cases that came out and lower court cases that redefined the standard for involuntary civil commitment that would apply in all 50 states. And we'll return to some of those cases in a moment. But at present, what you see is essentially a uniform standard all across the United States, although every state has its own specific law for involuntary civil commitment. And in general, what it requires is, one, a showing of mental illness, and two, a showing of dangerousness. And that term dangerousness applies to either danger to yourself or a danger to other people. And so it's important to sort of break that up a little bit, since it relates directly to the topic today in terms of understanding the ethics behind the government's use of power to restrict someone's liberty for the sake of either themselves or for the protection of the greater community. And so with respect to mental illness, that first component, it's really something that's very easy to define. And in the court system, when a police officer or a judge or a medical professional petitions for an individual to be civilly confined, it's almost a foregone conclusion that they're mentally ill. It's not really an intense part of the analysis that ultimately leads one to be civilly confined. Oftentimes they have an extensive history of mental illness, so it's just assumed that they're still suffering from schizophrenia, bipolar disorder, or whatever the case may be. And the courts really just rely on medical expert testimony to say, check off the box, they're suffering from a mental illness. Where the difficulty arises and where a lot of the litigation arises is in trying to determine whether this person is really a danger. And so as I mentioned before, and as one of those Supreme Court cases made clear, in the case is Addington v. Texas, which was decided in 1979, it has to be danger to either yourself or a danger to others. And so there's a couple of different ways of understanding this. I think the simplest way of understanding it is breaking it up in terms of timing and type. So in terms of timing, when courts are considering whether somebody should be civilly confined because they're a danger, it has to be an imminent danger. It has to be an immediate danger, right? We don't civilly confine people because they threatened to kill someone 10 years ago. We may have civilly confined them at the time, but it has to be an immediate or imminent threat of harm. With respect to type, it can be a danger to a person bodily, so physical injury, suicidal thoughts, cutting yourself, that sort of thing, wielding a knife in the middle of Times Square, that sort of thing. It can be a threat to property, right? Someone who is acting in a very bizarre way in the middle of the street may cause an accident, cause not only damage to the person, to individual people who are driving, but also to property. And it can also be psychological, in terms of psychological damage to individuals because they see, very bizarre behavior. And that might be a little bit more difficult to give an example of, but, for example, if someone is exhibiting bizarre behavior and has what you might consider a weapon, even if they're physically incapable of causing harm because there are no bullets in the gun or it's a plastic knife, they can cause psychological trauma to someone who thinks, oh, they're about to be slit by the throat or to be shot. And so those are the components, and that's how it's sort of understood by the courts when we talk about showing of mental illness and a showing of dangerousness, either to yourself or to other people. And so it bears mentioning that in recent years, there's been a surge of civil commitments, not necessarily under the traditional lens of mental illness and dangerousness. So there was a case, Kansas v. Hendricks, that was decided by the Supreme Court in 1997, which allowed for individuals who were, you might call, persistent sex offenders to be civilly confined. It's the same exact framework conceptually. They have what they call a mental abnormality instead of a mental illness, but the definitions are very similar, and they are a danger in this particular case of engaging in predatory sexual behavior. And so one interesting thing that I observed as I've worked in these spaces is that the populations that are sometimes served, it used to be that a large segment of the population would be somebody who just had bipolar disorder and schizophrenia, or maybe some other traditional mental illness that's more well known. Whereas now a lot of these psychiatric institutions have swelled up because they're housing, in addition to that population, a different group of people who are what we might call persistent sex offenders. So it's a little bit of a different landscape. Moving on into the second section, where the state gets its authority for depriving someone of their liberty. It's an important question. If you're going to deprive me of my liberty, you have to do it right. And if you don't, then I can't be civilly confined against my will. And that's, again, one of the important lessons that came out of the various Supreme Court cases during the 1970s. In particular, I'm thinking of O'Connor v. Donaldson, which was decided in 1975. There's an interesting quote in that case that says, it doesn't matter that the state it doesn't matter that the state has enacted a law. The question is whether it's constitutional, right? So the mere fact that a government, a state, whatever sovereign body makes the decision to put a law in the books to civilly confine someone, that's not enough, right? We need to understand where that authority comes from. And that same case that I had mentioned before expresses that. In Addington v. Texas, the court makes it very clear. There's only two sources of authority that the government has to deprive someone of their liberty in this way. We're not talking about the criminal context. We're talking about the civil context. The first one is the state acting as parens patria, which is Latin for parent of the country. And so the court explained that when the state acts as a parent of the country, it has the authority to act in the best interest of each individual person within its borders. And so this, as we'll see in a second, corresponds directly to that use of civil commitment where someone is a danger to themselves, right? Because the government, as parens patria, as parent of the country, has the authority to act in the best interest of that individual to prevent them from harming themselves. The second source of authority is the police power that every sovereign nation has. And we've probably heard it in the context of maybe totalitarian regimes, the police state. But the reality is that every nation has the authority to police the individuals residing within their borders. So this police power is exercised as a way of ensuring the protection of members of the community. So the focus here isn't on the individual, it's on the community at large. And so you should see by now how the police power corresponds directly to that second version of civil commitment when an individual is mentally ill and a danger to others. The state has authority under its police power to deprive this individual of their liberty, not for their own sake, not necessarily to make sure they get the best treatment, although that is obviously a legitimate and important concern. But at that stage, it becomes important for the government to exercise its authority for the sake of the entire community, And so our question today is understanding the moral ethics behind the state's use of those two powers, which is used to authorize one of two versions of civil commitment. And so a lot of people get confused because they think of parens patria and police power as giving them the ethical justification, but that's not really the case. Parens patria and police power provide the authorization, but we need to ask the question one level deeper: are those actions ethical, and in what circumstance? And so, in thinking about this issue, there's a couple of ways to approach it. One way to approach it is to assess it from, practical ethics, like a common sense type of approach. Another, maybe more cumbersome approach would be to consider it from a philosophical perspective. And that's what we're going to do in the next few minutes, trying to understand from a philosophical perspective, how can we understand the government's use of its parens patria power and of its police power ethically to ensure that they're doing the morally right thing, right? And so, just to take the first version and start with that. So the first formulation, the first version of civil commitment says that the state, acting in its parens patria capacity, has the authority to civilly confine someone against their will when they have a mental illness and when they're a danger to themselves. And one way of understanding this from an ethical perspective is to look at utilitarianism. So anyone who's taken an introductory course in philosophy should be familiar with the two ethical schools of thought that we're going to talk about today. One being utilitarianism and the other one being Kantian ethics, which we'll get to in a few minutes. So essentially, utilitarianism can be boiled down by the maxim, or by the phrase, the greatest happiness principle, which says that the state acts morally whenever it seeks to maximize the happiness for the most amount of people. And there's a negative version to that, which says the state has an obligation to minimize unhappiness to the maximum amount of people. Kantian ethics is a little bit different. Anyone who knows anything about Kantian ethics is probably familiar with the categorical imperative. And there's four versions of the categorical imperative, but the one that we're concerned with is the formula of humanity. And this formula says that the state, and I'm paraphrasing here to make it applicable to our context, that the state is moral in acting when it acts towards a human being as an end in him or herself, and never as a mere means. So actions are ethical. Government actions are ethical when it's done in doing so, it's treating someone as an end in themselves and never as a mere means to an end. And we'll unpack that because I know it's a lot. So let's start with Kantian ethics. Kant says we should treat people as ends in themselves. To treat someone as an end in themselves is to value their choices, value their humanity, value their autonomy, value their goals, value their decisions, to value them as a human being. That's what it means to treat someone as an end in themselves. So when I take my son to soccer practice because he likes soccer and I am dedicating time to that act, I am treating him as an end in himself. If I were to take him to soccer practice because I'm a frustrated soccer player and I was never able to make it to the big time, and I want to live my dreams through him, even though he despises soccer, I'm treating him not as an end in himself. I'm treating him as a mere means, right? A mere means to a different end. So how does this relate to that first formulation of involuntary civil commitment, right? The concept that the government can deprive someone of their liberty when they're mentally ill and a danger to themselves. Well, the government is acting ethically in the sense of using its patria power and caring for that individual in a particular moment in their life when they cannot care for themselves. So in contrast to the other version where you're concerned about other people, when the government is civilly confining someone who's a danger to themselves, they only care about that one individual. And in that context, they are treating that individual as an end in themselves rather than a mere means, rather than a means to an end. So that's a really important concept for anyone who has the authority to civilly confine, for anyone who has the authority to petition for civil commitment, that if you're doing it on the basis of this individual potentially hurting themselves, it's important and it's ethically significant that you value their humanity in making that decision. If you're not doing it for that purpose, then you're not really honoring the humanity of the individual, and the ethical justification for depriving that person of their liberty under that first version of civil confinement kind of collapses on itself. So remember, Kant says that you should never use someone as a mere means to an end. Now, what does that mean? To use someone as a mere means to an end is very different than using someone as an end in itself. There's a difference there. And there's a couple of examples I could give. Probably the most well-known or one of the simplest is a bank transaction. When I go to the bank, I'm using the teller as a means to an end, right? I don't really care about the teller, but I need the teller in order to get my money. The teller, in turn, needs me in order to have a living wage, right? If there were no customers, they wouldn't have a job. So we're each using each other, but we're consenting to that use. So we're using each other as ends, as means to an end. That's different than using someone as a mere means to an end. When you use someone as a mere means to an end, that means you're using them in a way where they can't consent to the action. So for example, if I ask someone to loan me money and I have no intention of paying them back, but they don't know this, I am forcing them into a situation in which they can't, in principle, consent. And that's using someone as a mere means to an end. And so the question should pop up in your head, well, isn't that what's happening with civil commitment, right? When you're depriving someone of their liberty, they're not consenting to that action. So does the Kantian framework really make sense to justify this from an ethical perspective? And the answer is yes, because when Kant talks about valuing the humanity of someone, the reason why he places such a high value on humanity is because of our capacity for cognitive and rational thought. Compared to animals, compared to inanimate objects, humanity is valuable because of our capacity for rational thought. But what happens when someone is going through a psychological episode in which they are a danger to themselves? In that particular moment, they lack the capacity to make a rational decision, because I don't think it would be disputed that it is not rational to injure yourself for no reason. And so Kant would say, in the moment you choose to civilly confine someone because they're a danger to themselves, you are acting ethically because you're acting how they would act if they had a rational capacity. But because they don't have a rational capacity, you're going to use your patrens patria power as parent of the country to take an action for the better welfare of that individual, with the expectation that with treatment, counseling, and so on, they will eventually graduate, right, to leave that episode and be able to return to society. Now, that's sadly not the case with everyone, but that's the expectation. So you can see how understanding that the overarching theme is valuing the humanity of an individual, you can see how approaching civil commitment from that perspective becomes more morally defensible and ethically justifiable. Now, let me move on to the second formulation. So if you remember, the second formulation says the government can use its police power to civilly confine someone when they're, one, mentally ill, and two, a danger to other people, plural, more than one, so to a community at large. And we had talked about utilitarianism a few minutes ago, and what utilitarianism says is that the government should always act in a way that it maximizes the happiness of the greatest amount of people. And negative utilitarianism just flips that on its head and says you should always act to minimize unhappiness to the greatest amount of people. Now, if you just were to hear that, you would say, well, that sounds a little wrong, right? We're going to deprive someone of their liberty so I can be happy. Well, we have to understand that philosophers don't think the way we think, and they don't use language the way we use language. And so they define happiness in a very particular way. And so Jeremy Bentham and J.S. Mill, they understand happiness as pleasure and the absence of pain. And so viewing it from that perspective, the absence of pain, we can see a direct connection between government using its police power to prevent harm to a community of people. And that's what we're referring to. Those situations where someone indicates that they're planning to bomb a school. Those scenarios where someone is wielding a dangerous object in a high traffic area. Those types of scenarios, the government is authorized under its police power to deprive that individual of their liberty in that particular moment because they demonstrate an imminent, immediate risk of harm to the community at large. And so that's consistent with utilitarianism. And actually, anyone who knows a little bit about utilitarianism knows that it's a political philosophy. So it specifically addresses the government's use of power. That's what it's talking about in the criminal context, in the civil context, in any context. The government has this power to deprive one individual's liberty if doing so maximize happiness to the greatest amount of people or minimizes unhappiness to the greatest amount of people, and defining happiness as pleasure and the prevention of harm to other people. So that's essentially how these frameworks work together, right? That it makes sense. We should never deprive someone of their liberty simply because they are burdensome. We shouldn't deprive people of their liberty because they are unruly, because they're inconvenient, because they're a disturbance, because they're unseemly. Those aren't ethical reasons for depriving someone of their liberty. The only reasons for why we would deprive someone of their liberty is because they're at risk of imminent harm, either to themselves, in their body, in their mind, or in their property, or to the community at large. Again, to those people's bodies, minds, or property. Those are the only two. And so when we understand that from the perspective of Kantian ethics and utilitarianism, it helps inform the way we think about civil commitment. So just to conclude, I think it's worth pointing out what was the point of this entire presentation, right? It's a lot of philosophy, it's a lot of legalese. And so what's the point for those attending this conference, and how can it be of value to you in your practice area? Well, I don't doubt that many of you are working in these spaces, whether it's as a practitioner, as a therapist, as a caseworker. Maybe you're a person in position of power in law enforcement that has the authority to petition for civil confinement. And I think understanding the ethical foundations for the government's authority in making the decision to civilly confine someone can help make us a little bit more sensitive to what's actually going on in their lives. I think it helps makes us a little bit more sensitive into what they've gone through. Maybe for a caseworker or social worker, it helps to understand whether someone was voluntarily confined versus involuntarily confined because of the different standards that are at play. It also helps us always appreciate and value the humanity of someone when they're being deprived of their liberty. So often these government systems that are in place, they kind of rubber stamp these petitions, especially when it comes to establishing whether someone has a mental illness. It's almost a foregone conclusion, but holding the government accountable to that standard, to that ethical, moral imperative to value someone's humanity, or to ensure we're only doing this because we're protecting the community from an imminent threat of harm. I think that helps us exercise that authority in a more respectable and justifiable way. And the last thing I would say is maybe these ethical justifications don't do it for you. Perhaps these philosophical discussions really don't sound that convincing, and that might be a sign that perhaps it's time to challenge the system. Right? Nothing would have changed if there weren't medical advancements that allowed people to see that jail wasn't the answer for individuals with mental illness. And nothing would have changed if advocates didn't come out and say, hey, listen, we need to have mechanisms to ensure that individuals aren't just being rubber stamped into these commitment facilities, and to ensure that there's some due process for a periodic review to make sure they're not forgotten about in those mental institutions, right? And nothing would be done today in many states. There's a right to counsel in these commitment proceedings. In New York State, it's the Mental Hygiene Legal Service. I know that there are similar names for agencies in other states. That was all accomplished through advocacy, because we want to be ethical in dispensing our responsibility toward every member of our society, which includes those who suffer from mental illnesses and may be a danger either to themselves or to others. So I hope this was an insightful presentation, and I hope that you were able to glean maybe a little bit some newer perspectives on the history of civil commitment, the justifications for civil commitment, the foundations for civil commitment, and I hope it helps you be a better advocate, a better practitioner, a better person in a position of authority to help this segment of our community. Thank you.
Good day, everyone. I'm talking today about accountability for civil commitment. I've entitled this chat, Accountability for Civil Commitment Means Giving a Count. We think we know what civil commitment is, the forced, state-sanctioned or state-administered detention of a person on the basis of mental illness or on the basis that they're dangerous to self or others, and mental illness, of course, for a somewhat undetermined period of time. But civil commitment is only a part of the broader picture of involuntary care. And involuntary care also includes, in addition to civil commitment, guardianships or conservatorships, which restrict people's power to decide how to run their affairs, which were traditionally used for people with dementia, and appear much more widely used today, as in, for example, California, to address a perceived nexus of homelessness, illicit drug use, disruptive street behavior, to very limited national estimates exist about that. There's also seclusion and restraint, which is part of involuntary care, where a person either must stay alone in a room or must be restrained or have their limbs restrained or attached to their beds or less mobile. That occurs not only in the mental health system, it occurs widely across healthcare systems too. And then there's also forced orders for medication or for ECT, electroconvulsive treatment, still occurs, where a facility with such an order can override a person's objection to receive those kinds of treatments. So that's the broader picture of involuntary care, of which civil commitment is the sort of outstanding, more salient, more visible, more discussed feature. What I'm really concerned about when I look at the picture of involuntary care in the United States and in many countries around the world, but not all countries, is the lack of data about involuntary care, and specifically about civil commitment, the lack of numbers. I will make a case today that in addition to the ethical dilemmas and quandaries that, distinguish civil commitment when it's practiced, the ethical dilemmas and quandaries about how, when, whether we should commit someone, override their objections, etc. In addition to that, at the policy level, the lack of data is itself a major ethical violation. Violation of what? It's a violation of key bioethical principles that we talk about when we talk about healthcare systems and healthcare delivery and healthcare in general, like the principles of justice and respect for persons. Why? Because the lack of data ignores a lot of issues about civil commitment. First of all, it's kind of weak basis as an intervention. That is, we don't know exactly what it accomplishes and whether it accomplishes what we often state it should accomplish, which is to preserve people's integrity, preserve people's health, and preserve people's lives. We're not certain at all whether it accomplishes that. We also, the lack of data also hides any inequalities in the application of civil commitment across jurisdictions, including disproportionate use with people of color. And I'll come back to that. Also, because a lack of data robs power from the people who, based on their own experience, critique involuntary commitment. And they may be dismissed for doing so. And also, more generally, the lack of data just compounds the general scarcity of data on involuntary care in general. And that misrepresents the nature and the functions of the mental health system. It may really mislead people into thinking that a lack of coercion, it can explain some of the system's failings, The reason many people might think that is because there's no data for them to tell them on the actual extent of coercion today as we speak. So for all these reasons, I'm very concerned about addressing the lack of data about involuntary commitment at the policy level. I'll describe what kind of data that is. I think that no matter how you frame civil commitment, whether you represent it as essentially a massive curtailment of liberty, which is the phrase the Supreme Court used in 1972 to characterize civil commitment, or whether you represent it as just a life-saving intervention, regardless of everything and where in the spectrum you are of looking at this, you should be extremely concerned that there's almost no data to paint a picture of who's involved, how often, and how long does it last. Almost no data. And I'll document this in a few moments. So first, the question I want to ask is, at the policy level, who should be accountable for civil commitment to the public when it comes to acting in the public's name and using public funds? So I'll try to describe, first of all, who should be accountable. Secondly, I'd like to describe or make a case for, well, what should accountability mean at the policy level? How would we know that a party who's accountable is fulfilling its duty to be accountable? What does that entail? And I think there's some extremely simple answers. And the simple answer is in the title of this presentation. Accountability means giving a count. I'm going to repeat it 10 times today. Accountability means giving a count. And then I'd like to discuss, well, to what extent does that sort of accountability exist today across the United States, based on some research me and my team have done? And then thirdly, I'd like to ask the question, well, what are the problems that result from not having widely available, clearly defined public data, state by state, on civil commitment? And then I'd like to ask, what are the barriers? What are the barriers? What are the obstacles, as far as they've ever been researched, which is not much, to actually having publicly available, clearly defined data on commitments and other forms of involuntary care? And then I'd like to conclude by describing what I'd like to do about it, and by trying to involve as many of you as possible in accomplishing this task of holding states more accountable by providing more data on civil commitments. So let me then ask the question, who should be accountable to the public? Well, at the policy level, the simple answer is the individual state, because the individual state, through two main departments, oversees and supervises civil commitments and other forms of involuntary care. Which departments are those? Well, first, on one side, you've got departments of health or mental health or behavioral health or health and human services or health and social services. That's one kind of department. The other kind of department is the Department of Justice. Why those two departments? Because departments of health and mental health and so forth, they have three main functions through which they're overseeing commitment. One, first of all, is they own some facilities where people are committed. But most of the facilities, they license. The Department of Health licenses facilities. It also licenses professionals that execute, that oversee, that administer, that act in commitments. It also, the Department of Health, in joint activities with counties, and the federal government sometimes, oversees ombudsman kinds of mechanisms, complaint investigations, protection and advocacy offices in different facilities that are joint federal state kind of mechanism, and also commissions that are assembled every decade or so to look at the issues around civil commitments and mental health generally. And in addition to that, the Department of Health gathers, analyzes, and disseminates data from counties and facilities, and also transmits a lot of that data to federal agencies. And that gathering and disseminating and analyzing and transmitting data is also shared by the Department of Justice. It also gathers individual data on law enforcement and on court and judicial activities. And law enforcement and the courts are directly involved also in commitment. So when I ask the question, who should be accountable? It's the state, the individual state, through their departments of health and the Department of Justice, both of which are tasked and regularly do collect statistics on the services and the clienteles that they serve or that they manage by law and by approved regulations. So who should be accountable? The individual state and the departments of health and mental health or behavioral health and the departments of justice and their leading officials. The next question is, well, what does it mean to be accountable? This question is not often discussed in relation to behavioral healthcare settings. And when it's discussed, it's usually in terms of the degree to which a given department has met stated goals, let's say, regarding reducing the level of certain distress in the population in general, or in certain client or potential client groups or age groups, or generally increasing access to certain services or facilities for certain client groups or populations. But when it comes to involuntary care, however, accountability, I'm making a very strong case, must involve something quite different, but very simple, which is meant for other sorts of health services. And again, that is giving a count. The accountable party rightfully is expected to describe what happens. This is accountability is just answerability. You're simply supposed to answer a very simple question. What takes place? What took place this year? What happened? Who was it? Who was involuntarily committed? How many instances were there? How long did they last? We don't have to go into big ethical issues about, was it right to do what you did? Well, there's a law that says it's legal and it occurs all the time. Could you please just describe what happened? Could you please tell us how many instances of involuntary care, as you defined it, occurred? Could you please tell us how long they lasted? Could you please just tell us in aggregate counts? You don't have to tell us exactly what the names and addresses of those people were. There are no confidentiality issues when we're talking about population level data. Many counties release this information on their websites too, but not the majority of counties. A few states release it, as I'll document, not the majority of states. But this is, therefore, we're talking about simple, descriptive data, giving account. Accountability means giving account. Does a state department of mental health or justice release annual figures with accurate aggregate counts of different instances of involuntary care that occur in the facilities that the department licenses to operate, or that pass through the mechanisms that the state specifies in the laws that regulate involuntary care? And moreover, having done that, if it's done that, having given those figures, does the state or the agency point out gaps or unknowns and ambiguities, or lacks of definitions in the figures that it releases? And does it describe goals or measures to increase the accuracy of the data that it releases? And to the extent that a state does these things, well, we can say that it is minimally fulfilling its duty at the policy level to be accountable for involuntary care, which directly involves the deprivation of liberty, regardless of any other way that one wants to frame or describe involuntary care. It's a special case. Could we please inform our publics of how often it occurs, the characteristics of who's involved, and at least how long it lasts? So, I now want to turn to the extent to which this occurs, this sort of basic giving account occurs across the US. What is the extent of state accountability, as I've defined it, as giving account, occur across states in the United States? The answer is very little. So we can say that accountability is dismal, or generously stated, poor, very poor. There's little publicly available, usable, that means understandable, data comparable to the usable, publicly available data on criminal justice arrests, criminal justice incarceration, criminal justice probation and community types of measures that occur as a result of criminal justice incarcerations or arrests. So when you look at the situation of involuntary care and involuntary detentions, and you compare to the situation of involuntary criminal justice arrests and incarcerations and probations, it's the lack of data is striking. In 15 minutes, I could go to a computer and type FBI statistics on arrests and could be given a breakdown of every kind of type of arrest or criminal justice offense in the United States, almost by county. I could map it. And I could map how long people are arrested and what kind of jails or prisons they're sent to, and for how long, and for what kinds of offenses. And so that I could find in 15, 20 minutes. And the federal government gets that kind of data from states and publishes annually in very detailed reports. But nothing of the kind occurs when it comes to involuntary commitments and involuntary care and its different instances in general. So overall, when I looked with my associate G. Lee in 2020, just 8 states during the 2010s, during that decade, released any clearly defined annual data on the frequency of just involuntary holds, which are defined as relatively short term, although actually from state to state, they vary from 4 hours or 1 day to 31 days. So we often tend to think of involuntary holds as 2-3 days, but that's a kind of a picture we have based on the lack of data. We just don't know how long people are held. In fact, we do know what some of the laws state, but we don't know how long this actually occurs and the duration of that. So what are these 8 states? Vermont, Connecticut, Massachusetts, Virginia, Florida, Wisconsin, Colorado, California. These are 8 states that somewhat regularly during the 2010s released fairly well-defined figures on involuntary holds. Not necessarily much more than that. Only 5 of those 8 states actually released some socio-demographic information about those who were subjected to commitment. Only a few even made a distinction between children and adults. So it's hard to calculate any population-wide rates because you can't, you don't know if you should have a denominator, which is the whole population or just adults. Very few states gave the ethnic or racial breakdown of the clients, the gender breakdown of the clients, for example. So it's fairly well defined, but it's not very complete for those 8 states. Most of those 8 states also had a dedicated report where they clearly defined what they were talking about. Another 70 states released some figures some of the time, often lacking elementary definitions that made it impossible to answer what took place. What happened during your year in your state regarding involuntary commitment? There was just no way to figure, was this just a file that was opened in some court? Was this a person who was actually detained? Was the police involved? All this is unavailable. Only 8 states gave some data around longer-term commitments, just in terms of, which also range wildly according to their own definitions, from about 14 days to over a year. Only 8 states gave some definition that you could say a person fell into that bucket of between 14 days and over a year. Only 1 state of 50 actually gave a figure of the average length of stay for adult involuntary patients, and that was the state of Vermont. 1 of 50 states indicated how long. So this, I remind you, is in the age of electronic medical records, when we know precisely when a file is opened, or when a person arrives, and when a person leaves. Only 1 state actually provides that sort of information, and that's for longer-term stay. No state, 0, provided any information on what we keep holding as the picture of involuntary commitment, which we call involuntary holds. We call them short-term. We have no basis, in fact, in any data available in the United States to call it short-term or mini-term. We just don't know. To push that point further, only 1 state actually counted commitments and unique people, individuals who were committed. Think about what that means. Only 1 state allowed us to actually calculate how often a person, an individual person, may be committed. How often? We're often given the picture that commitment is primarily a revolving door phenomena, where the number of commitments is really gathered to a very small group of people who use most commitments. They're committed 30 times a year or so. We have no clue. There is no data. So all this is hearsay. We have no way to calculate whether commitment is the first point of entry with the public system for young people, disaffected young people, alienated young people, troubled young people, or whether it is actually primarily a revolving door phenomenon for people who are more chronically, more long-term disturbed or distressed. We don't have the data to say that, because a single state allows us to calculate it during the 2010s, and that was the state of Colorado. It gave during that time the number of unique individuals and the number of commitments. And we could calculate that only 8% of people who were committed more than once in a given year. That means for 92% of people, it's only once. And we don't know if it's the first time for them. So these are big questions to answer that we completely lack data, publicly available data, which may actually be collected by the states, but they don't release it. At least 49 of 50 did not release it. So I'm excited in a sense of, this makes me upset to know that such basic data, which involves what the Supreme Court called a massive deprivation of liberty, and which can involve stigma, which can involve incredible distress, the person is just ignored. So that's the extent of accountability. Now, and that's just about civil commitment. When you look at other forms of commitment like guardianships and conservatorships, all I can do is refer you to that letter that was written by by Senator Elizabeth Warren and by the previous Attorney General, released asking states to, hey, this was as a result of the Britney Spears affair and the media storm that created. These two, senator and the attorney general, asked, each other, hey, how many people are under guardianships and conservatorships in your state, in the United States? Could you please tell us? We don't know. So they're writing in a letter that we just don't know. And that's only guardianships and conservatorship. There's a bit more data on seclusion and restraints. And we also have some data on how that has evolved in a few states. Pennsylvania, for example, released some data on that. But Pennsylvania releases almost no publicly available data on commitment, but it does release some on seclusion and restraint. And when it comes to medication orders, there's only two states during the 2010s, Colorado and Texas, that actually released some data on involuntary medication orders and involuntary ECT orders. Two states. I want to also give the example of Colorado. I've mentioned it a couple of times. Colorado is a fascinating state on that because up to about 2017-18, it released the most detailed data that you could almost imagine. It gave figures on short-term holds, long-term holds. It counted the holds and it counted the people. It gave figures on ethnicity and gender. It gave figures on medication orders. It was so detailed, it was almost unique. But then it stopped the spigot. It just closed it. It's no longer releasing data. You have to really ask for it. And not only that, it stopped doing that after it revealed that beautiful detailed data that it had been releasing was undercounting commitments by about half. It was great, but it wasn't accurate because half of commitments were occurring in facilities that were not designated, according to Colorado, to receive involuntary patients. And not only were they not designated, they just didn't even have to report. And when they did, and in 2018, for the first time it released those figures, the commitment figures jumped by 100%. So you see the sort of situations that could occur state by state. It's an extreme example, but it shows you that possibly with some very good intentions, Colorado was at the same time that it was giving us very detailed, fine-grained data that could help us get a great picture. It was only half the data. So the question is, what's the problem with the lack of data? What's the problem when there's no public numbers available to stakeholders and researchers? Well, it just limits any discussion of involuntary care. I mean, if you can't draw the contours, if you can't say how many people, you can't talk about it besides just invoke ideological arguments or ethical arguments, one pole or the other. You could just get passionate, but without advancing at all on, can we just describe it, please? See, a public number, we can say, well, there's close to 2 million people incarcerated in the United States in prisons and jails. That's a public number. How did that public number arrive? Because there was a will at some point from the authorities, but also from advocates to just say, hey, there's this notion called mass incarceration. Does that make any sense? So they begin to count. And so eventually we have these numbers so we can talk about it and we can see what feeds into this notion. We could see what things we can act upon, whether they're, types of bail procedures or ways to keep people kind of chained to the system even after they're released. We begin to see that as we crystallize the notion of mass incarceration with some public numbers. We don't have any public numbers for involuntary commitment. We don't have public numbers for involuntary care. So we can't discuss it because we can't even crystallize that notion. We can't make it concrete. We can't discuss it. We have no numbers. We can just say, oh, it's just about treating the mentally ill. We don't even make the distinction that the law makes between voluntary and involuntary. So we're really hampered from moving forward and run a proper mental health system. We're not informing ourselves of what we're doing. So who knows? Who knows, maybe privately, who's in a situation to have access to the figures and maybe to distribute it to some researchers? Why not distribute it to the public? Why don't we talk to ourselves about what we're actually doing in the name of the public and using public funds? That's the point. So, there's a lot that's not known about civil commitment, a lot. And public numbers will not solve all of that, but they will certainly put us on the way to compare states with other states, to compare the same state over time, to compare the country over time, to compare the country with other countries with similar laws, but maybe different healthcare systems. It could begin to answer huge questions about maybe what happens after commitment. The big questions are not about data, about just describing. The big questions are about answering, does commitment meet the goals we expect it to meet? This is the big question. But if we don't even have an answer to how many people, who are they, and how long, how could we even begin to discuss what happens to people? We don't know whether suicides are prevented or suicides are increased. We don't know whether, as recent data shows, Black people especially are disproportionately committed and receive orders for forced medication. And we don't know whether that's temporary, whether that's in some jurisdictions, whether that's a pattern over time in the whole system. We don't know whether the system, the phenomenon is a revolving door or not. We don't know whether it's the first time contact. Think about it. The first time contact for maybe young adults with a mental health system. We don't know if commitment with the police bringing you in somewhere is actually your first encounter to something we then say, you should really be more in touch with that system. We have no way to respond to these really basic questions. I'm not saying no one's trying. I think maybe a number of people are trying, but they're hampered by the lack of data, and they don't put their finger on the fact that there's a lack of data. We cannot describe the system. We cannot answer the simple question, what happened? What took place? So I'm sort of repeating that. Let me conclude. Well, let me mention, I think I'm coming to my 30-minute sort of limit or close to it. And I want to say that what I didn't address right now so far is what prevents us from doing that? What prevents us from gathering data? You may have your views, and I would love to hear them, by the way. I would love to hear your views on what contributes to this lack of data. I have a few ideas myself. I think that it's complicated to report about coercion because many episodes, most of them, maybe up to 60-65%, may take place in private facilities, not public facilities. The behavioral healthcare, psychiatric healthcare system today in the United States is primarily, maybe up to 65% of it, occurs in privately funded facilities. And they may have different standards, maybe according to regulations that are not well known, about reporting what occurs in their facilities than publicly funded facilities. So that's an unclear thing here. Or maybe the enforcement standards of a state are kind of lackadaisical, or maybe the state just doesn't have enough money, doesn't have enough resources, or has not made it a priority to actually collect the data. Or if it collects the data, it just sits there. It's on these forms, it is received, and no one is tasked to look at it. Or maybe the state doesn't have a legislative mandate that actually spells out, as some states do, like, for example, Massachusetts. They have a mandate that says, or Florida also, every year a report shall be prepared for the legislature and released to the public, or something like that. Some states have that in their laws. Is that what it takes? I don't know. I don't know how many states may have that, such a mandate, and still not act on it. I don't know how many states act on it without a mandate. So it's unclear. It's not been researched. So the attitudes also of the public and the professionals and the legislatures obviously play a role. Because if we just view coercion and forced treatment as only in the person's best interest, they've been robbed of their will, they have no insight, they're like objects, it's for their own good. We just got to do it. If you just look at it that way, then you don't care about, well, I don't know if we need any special statistics on that, because it's just mental health treatment. Nothing special about it. I disagree. I think there's something very special about it when you deprive someone of their liberty. It's pretty simple to me. I'm not saying we shouldn't ever, not coming to that position, but when we do, we have an obligation to describe what we do and be honest about it, about how we describe the mental health system. So we don't mislead people to think that the mental health system is just about loving and caring. It may be other things too. We need to know that. We need to be able to discuss that. We need to be able to debate that with actual empirical data, figures, numbers. There's a lot more reasons I could say why this doesn't happen, but again, I'm extremely interested on your hypotheses, your views of why, maybe in your state, is data not gathered, what you know about that, what you think, what the mechanisms are, who's responsible that you might know, who is in a position to make changes to that. I have some ideas, but not for all the states. But I did put together a research project that I'm hoping will be funded with my colleagues in different universities, East Coast, West Coast, and Central of the United States, and looking to see and interview officials, both starting from the attorneys general and the heads of the departments of mental health and behavioral health, and down to data officials, all kinds of people, to really find out what is the problem. Like, what data do you gather? What data do you not gather? What's the problem with gathering this data, or if having gathered it, analyzing it, and having analyzed it, sharing it with the public, to really try to, and then find what the actionable potential solutions to any problems that these people bring up might be. Very interested in what advocates think, advocates from any kind of position, whether you see yourself primarily as a family advocate or primarily as an advocate for the person who's being committed, or everything in between. And what do you think of this situation? Isn't it very important to you, or is it important to you at all? Maybe that's also part of the attitudes. So we need to understand, and I would really, really like to hear about this, really putting out this sort of appeal to help me understand better and frame better the kinds of questions we need to ask, who we need to ask them of, so that we can reach the state as exists in a number of other countries. I can single out the United Kingdom, Australia, France, as three countries with very different healthcare systems. Some a mix of public-private. France is mostly public, also some private, and some are centralized, some are federal, like Australia, which publish annually very, very, very detailed statistics on all forms of involuntary care, and detailed suggestions on the accuracy of their statistics, and detailed steps and measure on how they're working to improve those statistics for the following years. And those three countries, very different political orientations also, each have a goal as a result of these figures to reduce involuntary care. They make it an explicit goal. They have parliamentary commissions and things that discuss reducing involuntary care as a result of being informed about its actual extent in their jurisdictions. So this is an impact of giving yourself feedback about what you're doing. Thank you very much. I really would like to hear from you. Please contact me by email and help me to create the first national database in the United States of involuntary care in the mental health system. Thank you very much for your time.
Hi, everyone. I'm Katie Donahue. I'm a Denver city attorney. I work in the mental health unit. And what we do is we prosecute, quote, mental health proceedings, mental health civil commitments in the state of Colorado. So I want to talk to you today about commitment proceedings from the state's perspective. Okay. A little bit about myself. I graduated from law school about 10 years ago at this point. I can't believe it's been that long. I was a public defender at the trial and appellate level for maybe about 5 years. And I always wanted to do more for my clients and the people that I worked with. And I got really tired of being told by my supervisors that I wasn't my client's social worker. So I quit being a lawyer and became a social worker. I got my MSW. I worked in that field briefly, but I worked in forensics. I worked at a community corrections facility, which is a state-run halfway house in the state of Colorado. And then I also worked in a competency restoration program that was in jail. So that was an interesting experience. I applied to my current job kind of on a whim, and it's been the perfect fit for me. So I'm in a unit with myself, another attorney. We have a kind of part-time third attorney and a paralegal. We're known as the mental health unit. And the main part of our job is we handle the mental health certifications, which is what we call our civil commitments. And we also handle involuntary medications and involuntary special procedures, such as involuntary electroconvulsive therapy and involuntary feeding tubes for persons with eating disorders, as well as people who require oral psychiatric medications but cannot take them in. In addition to that, we also do involuntary commitments, which is the terminology that we use for persons with substance use disorders. So we get involuntary treatment for up to 9 months for people with substance and alcohol use disorders. And then we also help out with involuntary placement for persons with intellectual and developmental disabilities. When someone's at the extreme range of that and needs to be placed in a special housing situation. Another new thing that we're doing is we're doing the extreme risk protection orders, which are known as red flag laws and to a lot of people, but we handle those for the county of Denver, and we work very closely with police. And then starting next year, our unit will be handling our restrictive housing bill, which was passed and goes into effect next July. So people are entitled to a hearing when they're in custody and they're placed in restrictive housing and solitary, things like that, due to their mental illness. So today I'm going to give a brief, I'm trying to be as brief as possible, overview of our legal proceedings, just so you get a sense and context for the work that we do. I find that Colorado is sort of a middle ground when it comes to the rights of respondents and how intense our hearings are and how intense and how many statutory requirements there are to place someone under an involuntary commitment. I also want to talk about what, quote, prosecution looks like, and there's a reason why it's in quotes, so stay tuned for that. And then I'm going to talk about the ethical considerations and provide specific examples that have come up in my work. And throughout this discussion, I want to highlight the rights that are afforded to the respondent in these cases. So I'm going to give you a brief overview of our legal process, but if you want to go back and refer to this slide, feel free. Our civil commitment is codified. Our involuntary feeding tubes and involuntary medications and involuntary ECT are not codified, but it's all under Title 27, Article 65. Before any involuntary commitment can start in Colorado, there has to be a 72-hour mental health hold. And there's two ways to that. There's the one that a lot of people are quite familiar with, which is what we call an M1, but it's a 72-hour hold placed by law enforcement or an emergency service worker in the community when someone's having a mental health crisis. The other way is a court-ordered 72-hour hold, and I'll talk a little bit more about that when I'm discussing my role. So after someone's placed under that 72-hour hold, they must be evaluated, and if they are evaluated and determined to be meet criteria, which we'll go over briefly again. They can be placed on a short-term certification, which is up to 3 months. That can be extended once, extended short-term certification. Once we get to the 6-month mark, it converts over to a long-term certification, which lasts 6 months, and that can be extended indefinitely. And the oldest case that I can think of on my caseload is actually from 1992. So these things can go on for quite a while. The way that the case gets started is once they're on a hold, a psychiatrist or a licensed psychologist will file paperwork with the court stating their reasons for why this person needs to be placed under a certification. At the same time, they can also file a letter for involuntary medications or involuntary special procedures. Once that is filed, the respondent is entitled to immediate appointment of court-appointed counsel. In Denver, we don't really look to whether they can afford an attorney. One is just appointed to them automatically. As you can imagine, it might be difficult to determine their finances at the time that they're being placed under a short-term certification. In Denver, also as part of the court-appointed contract with the court, that attorney, that court-appointed attorney, has to visit with them within 10 days of their appointment. We'll talk about this more in depth, but my role in the city attorney's office is essentially to act on behalf of the petitioner facility. It's very rare that we're not acting on their behalf. And then the respondent is entitled to a hearing or a jury trial to 6 jurors in district court. In Denver, it's actually Denver probate court. Upon filing a written request for review of the certification. In the alternative, or on the other end of the spectrum, once the doctor files a letter for involuntary medications or involuntary special procedures, the court has to set that within 10 days. And the obvious reason for that is if someone's needing involuntary medications, they need a hearing to get that administered as soon as possible. And a little fun experience that I had was our court really does respect this 10-day limit. I once had a jury trial request on a Thursday. The court set it on Friday to be heard on Monday. So that we went forward, full jury trial. It was a very fun weekend for me. So I want to go over the standards in Colorado. I believe that they're pretty similar across different states. They might be titled different things, but it's essentially these 3 things. So a danger to self, a danger to others, or gravely disabled. And I think what's really important to note here is we're no longer looking at imminent, not imminent danger to self or others. When we get to the certification, we're looking at recent danger to self or others, but not necessarily imminent, which is more with that 72-hour hold. So I'm not going to read you the legal definitions, but I'll give you a brief overview and provide some examples. So when we're talking about danger to self, obviously we're talking about suicidal ideation, attempts at suicide, but also self-harming behavior, cutting, head banging. And that's not only just for people with suicidal intentions. We can see danger to self in other direct ways, such as someone who's experiencing psychosis and banging their head to get rid of the voices, or we'll see people cutting their arms in order to dig out some perceived implant or microchip. So things that are a direct harm to oneself. danger to others, we're looking at threats or acts of violence towards others. One case that comes to mind is we had this young gentleman who had capgras delusions, and he believed that his family had been replaced with imposters. So he assaulted them with a frying pan in his home. So that would be a danger to others. And I like to think of, when we're talking about these standards and moving forward with time, I said it didn't need to be imminent, but let's say someone threatens suicide. They might not be a danger to self 2 weeks from now, but that fellow who assaulted his family, even if he doesn't really display any dangerous behaviors for a while, he still might be considered a danger to others for quite some time due to the gravity of the incident that led to his hospitalization. For grave disability, that's quite a long definition. Basically, we're looking at whether someone, due to their mental illness, it causes impairments to the point that they can no longer take care of their basic needs. So someone who is placing themselves at risk of harm because they can't navigate the community safely due to disorganization, or they're not eating or drinking due to delusional thought content. They won't be able to find safe shelter. They wouldn't be able to go into a store and buy groceries, let alone cook them for themselves. We also, in Colorado, we have a broader definition than I feel a lot of states have. And I don't even know if a lot of people in Colorado are aware of this, but gravely disabled was expanded within the last 10 years to include they're gravely disabled. They can't take care of their essential needs. And one of those essential needs being taking medications so that they're at risk of a significant psychiatric deterioration. So let's say we have a respondent who's on a long-term certification. They've been doing well, they've been taking their medications. However, they continue to lack insight into their mental illness. They don't think they're sick. They don't think they need medications. So for someone, let's say schizoaffective disorder, for someone having that, maybe medications are an essential need and they aren't able to attend to that. So without the certification, if they're at risk of a significant psychiatric deterioration, the court can find by clear and convincing evidence that they are gravely disabled. I think one thing to point out, I know I'm talking to a lot of different people today, but for those of you who are in the community placing mental health holds, so again, the law enforcement, the emergency service workers, I think it's very important. I know there's a lot of frustration about bringing someone to a hospital and then they're released very shortly. If you're filling out the form and alleging one of these, the more details, the better. And that comes to my desk, right? I'm seeing what's being written down, and the more details, the more likely the professional person, the psychiatrist, psychologist, might keep them longer than a few hours. And the more evidence I'll have going forward to keep them hospitalized if that's what's necessary. So a lot of people don't know what actually goes on in the courtroom for certifications. If the respondent requests a hearing or the facility has asked for involuntary medications, it's a hearing just like any others. So in my office, I really stress when I'm training my new attorneys, we are going to hearings to deprive someone of a substantial liberty interest. We're locking people up against their will, introducing chemicals into their bodies that they don't want there. And they've done nothing wrong. The only thing they've done is they happen to have an illness. So our hearings are quite long in Denver. They can be they're usually 1 to 2 hours long. And we make sure that we hit every single legal requirement by clear and convincing evidence. So we don't take too kindly to doctors who feel that this process is just a rubber stamp or it's a waste of their time. And that is a surprising attitude that we see. We like the facilities to recognize that they are taking away someone's basic human rights. So yeah, it's just like any other hearing. We're allowed to give an opening and a closing. We go first as the people. We will usually call the treating psychologist or the psychiatrist if we're requesting medications first. If there's family members involved, we will call them, but I'll get to that in a bit, how that's actually quite rare. We also have the ability to call the respondent. They don't have a Fifth Amendment right to remain silent in these hearings. But this is where ethics and clinical opinion comes in. You know, we're not calling the respondent to make them look dumb or like highlight their delusions. I really just ask questions to give them a voice. Sometimes respondent counsel doesn't want to call them because they can usually make the case against them for themselves. But I think if they want a hearing, then they have the right to speak during that hearing. So I just ask them, you know, what would be your plan if the court agreed with you? What do you want to come out of this hearing? And I basically leave it at that. So the respondent side, so once our case is done, the respondent can also present evidence, but mostly their court-appointed counsel will just cross-examine the doctor. I've seen respondent counsel call family maybe once or twice throughout my 4 years at this office, but again, it's very rare, and we'll get into that in a bit. One thing I wanted to note with the hearings is that my office is very aware that the relationship between the respondent client and the treating professional can be really damaged by these hearings. So it is really hard. You need to be, as a professional, you need to be really sure that this is helpful for the respondent, because the testimony that you're going to provide is not going to be easy to hear for the respondent. So we're very aware of that. We don't ever, again, just like when we're questioning the respondent, we're not really trying to have the doctor bring out the worst of the worst. We kind of make it legalese so that it's not too upsetting to anyone. So prosecution, it's in quote. The reason I put it in quotes is because I don't view myself as a prosecutor. This isn't the people versus the respondent. These hearings are the people in interest of the respondent. We're trying to do what's in the best interest of the respondent. And we don't represent the petitioner. We don't represent the doctor. We don't represent the psychiatrist, psychologist, or even the facility. We represent the people of the city and county of Denver. In the statute, our role is to, quote, conduct the proceedings. However, 99.9% of our cases, we, the people, agree with the petitioner that it would be in the respondent's best interest to have involuntary treatment. We also handle appeals. So respondents in mental health proceedings have the right to a direct appeal, and quite a few do appeal. They also are entitled to court-appointed counsel on their direct appeal. And maybe this year we've had about 1,000 cases filed, and I think we're maybe at 5 appeals for the year. Those are also very quick. The Court of Appeals also recognizes that these are emergent matters that need to be heard. So we only get about 2 weeks to file a response and file the respondent counsel to file the opening brief. So it's a very tight deadline so that they get an opinion out. And if the respondent is being illegally held, that they're released as soon as possible. And in the world of appeals, we know that can take some time, but they really do a good job speeding that up. One of the things I wanted to talk about, and that first bullet point, we were reviewing cases for legal sufficiency. We'll file motions. We interview the doctors. we have definitely dismissed cases because there's not enough written. So that's a good example of how we're not representing the petitioner. The petitioner files something and you have to have a factual basis for why you believe they're mentally ill and for why, due to their mental illness, they're a danger to self or others or gravely disabled. And if some doctors will just write 2 words, grave disability, well, that's conclusory and we will dismiss those cases. So I think that's important to keep in mind going back to the emergency and law enforcement filling out that initial mental health hold. Doctors should also be held to an even higher standard when they're filling out something to take away someone's rights for 3 months, 6 months, and maybe since 1992. One of the other things we do, which is kind of, I'd consider one of the most difficult parts of our job, is earlier I spoke about the court-ordered mental health hold. So any responsible person can petition the court to have someone placed on a 72-hour hold for evaluation. The court in recent years, because we're conducting the proceedings under the entire statute, has referred all family members, neighbors, loved ones that go into the court looking for help. They're referred to our office. So we assist, I'd say 9 times out of 10, it's parents of an adult child who's suffering from a severe and persistent mental illness. They will call us and we will lead them in the direction of getting a court-ordered evaluation. This can be an extremely frustrating process. I remember there was one parent, and I think we filed 3 petitions for court-ordered evaluations. And because the way the law is, they didn't happen. It didn't work out. They were evaluated and released in an hour, or law enforcement went out and didn't think they met criteria at the time, despite having the court order in hand. So, and even when this young man was placed under a certification on the 4th try, he was terminated from that certification too early. So I almost feel like I'm a clinician again and dealing with these family members calling for help. It is an extremely frustrating system. We don't have the resources and services that we need to make sure that everyone who needs a mental health evaluation gets one. And we don't have enough beds that someone who needs a little bit of inpatient treatment can get that. It's very difficult, and it can be extremely frustrating. But I also recognize the struggles that the other side has, and there are limited resources. Doctors at facilities are short-staffed, so they're basically doing triage. So is this person sicker than the person on the bed next to them, who could be incredibly psychiatrically ill as well? So it's not the greatest situation all around. Another thing I just note on the slide is in Denver, we try and be very proactive. We just recently had a complete rewrite of our statutes. So we give a lot of trainings to all of the facilities and doctors who are filing certification. We like to educate them on the new law, make sure that everyone's in compliance with the law. So there's a lot of outreach. And we also try and maintain really good relationships with the doctors and, well, psychologists are doctors too, but all the doctors that we work with in our field. Yeah, that's a part of my job that I really enjoy. So ethical considerations, obviously this is always coming into play. I said earlier, we're working under the clear and convincing standard. And for those of you who don't know, you think about a civil trial, if it's 51% you win, 51% of the evidence in your favor, you win. And then we can think of beyond a reasonable doubt in criminal trials, which is a very high standard. We're somewhere in between. It's a civil case, it's an intermediate standard, but it is higher. And we are expected to present a lot of evidence to take away these people's rights. We're always working in the best interest of the respondents, and we're always balancing the rights of the respondents and their needs, which can be difficult. Sorry, I jumped slides. I wanted to give an example of a case where my ethical considerations came into play. I was in a hearing and there was a doctor who didn't want to prep with me beforehand. But basically the testimony of the doctor during the hearing, the pleadings were fine. I thought this would be a great hearing. His testimony was that this person's insurance was running out and they were releasing them tomorrow. But he was trying to argue that this person was gravely disabled and couldn't attend to their essential needs to the point that they're going to be at risk of bodily harm in the community. And that didn't sit well with me. If you feel that they're going to be fine tomorrow for discharge. And you know, it didn't help that this doctor kept asking on the record, how much longer is this hearing going to be? So I made a judgment call. Obviously, I'm just conducting the proceedings, so I didn't dismiss them outright, but I let the doctor present his evidence, and then the court, you know, decided to dismiss that case and release the person that day, instead of waiting until the next day when their insurance ran out. So we have to make these calls and hearings all the time, and it can be hard. We hear the testimony of the doctor, and sometimes the respondents present really well, but the testimony of the doctors, you know, pretty damning. So again, we get to fall back on conducting the proceedings. So we just present the evidence and the court will do what they will do. But I know I said we don't consider these hearings to be a rubber stamp, but it's very rare that we lose. I think the people that the facilities are willing to file a certification on in Denver, those all have a lot of merit. There's no close call cases. I don't think we have the resources to involuntarily hold the close cases. So that makes my job a bit easier. So I said I would talk about family involvement. We do assist the family members when they're trying to get that initial mental health hold from the court. However, we don't really see them past that stage. So I wrote some recent changes. So, well, the one recent change is the respondent may designate a layperson. This is in the new statute. So they can designate a family member, a friend, someone that they have in their lives to participate in all the legal proceedings, in addition to having the court-appointed counsel. HIPAA still applies to all of these proceedings. So let's say a family member calls me up, a mother calls me up asking about her son who has a certification proceeding. HIPAA still applies. I should not and cannot be sharing their protected health information unless there's a ROI, and I'll always direct them to talk to the facility and the doctor. Another interesting thing is hearings are not closed to the public. They're not statutorily closed to the public in Colorado. Someone has to present good cause to close it. So if the respondent wants his hearing closed to the public, I'm never going to object to that. I don't necessarily agree with the law on that aspect, but you got to follow it. So going back to the hearings, the certification, the civil commitment hearings, I have a lot of speculation as to why that family doesn't really want to be involved. I think since family members can't be petitioners for a certification in Colorado, that's why they're not really involved. It's always going to be that doctor. A sad truth is that many of the cases, the people that come across my desk, they've lost their natural support systems. They don't have family or friends there to go there and testify. We see the most involvement of family in our eating disorder cases. So Denver, Colorado is unique because I think we have the only medical stabilization unit for eating disorders in the country. So we're one of the few states that can do involuntary treatment for people with eating disorders. So that is where we see the most family involvement, and generally it's parent involvement. However, every single case that I've had where the family is quite involved, the family absolutely does not want to participate in the hearing. The family will call me and tell me that they absolutely think that their child, the respondent, needs treatment, but they absolutely do not want me to tell the respondent that that is the way they feel. And going back to the damage of the therapeutic rapport between the treatment provider and the respondent, you can imagine with a family member, you don't want to damage that natural support system. And the parents don't want their child to feel that they're out to get them. So we respect that. I've never forced a parent to testify against their will. Generally, they just don't want to testify. And we always have enough expert testimony of the doctor to make our case. So that is all I have. Please feel free to reach out to me. I left my email here. I love connecting with other people and answering questions that you might have. So I just want to thank you all for listening to me for the last half hour.
Hi, my name is Phoebe Bell. I'm the Behavioral Health Director for Nevada County in California. And before I jump in, I'll just contextualize that a little bit. Nevada County is a small rural county in Northern California. We're nestled in the Sierra Nevada foothills, and we're about 100,000 people, which is convenient. If I share any data later on, you can kind of extrapolate per 100,000 pretty easily from our county. And I'm here today to talk about what we call Laura's Law, or assisted outpatient treatment. And I'll probably call it AOT most of the time. Nevada County is essentially the birthplace of Laura's Law in California. And I'm going to talk a little bit about how Laura's Law came to be and what it's looked like to start that program in Nevada County, some of the ways it works, and some of the challenges and successes we've had with the program over the years. And I'm certain I will not cover everything that everybody wants to hear. So hopefully all of you would feel free to reach out with questions down the road if I don't get to everything that you would want to learn about this important subject. So Laura's Law began with a terrible incident that occurred in Nevada County on January 10th, 2001. One of our clients for our outpatient behavioral health clinic came into the lobby of our clinic and pulled out a semi-automatic gun that he had purchased legally and began shooting. And the first place he shot was through the reception window, and he immediately killed Laura Wilcox, who was a college student home on vacation from college for the holidays, who was volunteering in our department to help us out. He also shot many others in the office and in the building, killed somebody else in the waiting room, and injured and traumatized everyone in the building. People jumped out of second-story windows to escape the shooting. People were terrified. He left our facility, went to another location in Nevada County, and shot others, killed somebody else before he was eventually apprehended. His name was Scott Thorpe, and he had been a long-term client of our department. He had stopped taking his medications a few months earlier and had become increasingly agitated and aggressive. He'd left many voicemails for our psychiatrist that were threatening and aggressive, and mailed letters to us in the same vein. We also had received a call from his family members who were deeply concerned about him and let us know that he had access to guns and that they were scared he was getting violent. And despite all those, very clear warning signs and red flags and essentially cries for help, we were unable to and did nothing. Some of that is, failures on our department's part in retrospect, clearly, but some of it is not having opportunities or strategies that we could use to address the situation. The trauma from that event was intense, both clearly for people who lost loved ones and for staff and clients that were in the facility at the time. Many of those folks never returned to work or the lives that they led prior to that day. But the trauma was also intense for our community. It set us back a number of years in some of the work we were trying to do around reducing stigma around serious mental illness and creating acceptance of diversity of people in any community. And it took a long time to undo some of those wounds as well. One of the amazing things that came out of that terrible incident is due to Laura Wilcox's parents, Amanda and Nick Wilcox. After initial period of very intense grief, they quickly turned that grief into a desire to make sure this never happened again. If there's anything they could do to reduce the odds of this happening to anyone else any other time, that was their goal. They became involved with the Treatment Advocacy Center and with Assemblywoman Helen Thompson in California, all of whom were working towards assisted outpatient treatment as a strategy to help in certain situations. And the Wilcox family recognized that AOT would have been useful in Laura's situation and would be a good strategy to have in California. And through their combined work and efforts, in 2003, California passed an AOT law. That law, when passed, had no funding associated with it, and it was made voluntary for counties to participate. So it was a first step down the road, but certainly didn't get us there. At the same time, though, Nevada County, in part due to lawsuits filed by the Wilcoxes, which again didn't focus on money or things like that, their lawsuit focused on what are we going to do to make our community better and to get better services to people with serious mental illness. And so part of the outcome of that, and in part due to new leadership in the department and a desire to do things differently, Nevada County became very passionate about being the first county to implement Laura's law in California. And thankfully, also right around that time, California passed a proposition called Prop 63, or the Mental Health Services Act, which is essentially a tax on millionaires with all the proceeds supporting behavioral health services. So a funding stream came along as the opportunity to enact the law came along, and Nevada County then basically enacted the law through our Board of Supervisors in 2008. So what is AOT? And what does it mean to have an AOT capacity in your county? A couple of things I want to explain about it that are sort of myths or confusions that people sometimes have around AOT. First and foremost, it's essentially court-ordered outpatient treatment. And it's really important to underline that outpatient part. This is not court-ordered, locked inpatient care. Different laws govern that strategy. This is a step below that. It's an intervention that's less invasive, less restrictive, and hopefully can help get somebody to a safe place. Secondly, it's a civil process. And again, I think people often hear the court part and assume criminal associations. And being a civil process, there's no threat of any kind around jail time or criminal history or things like that. It's purely a civil process. What it is a strategy to reach a high-need small group of people who aren't able to engage successfully, mostly due to the symptoms of their mental illness and perhaps their paranoia or anosognosia, makes it hard for them to engage in outpatient care. And it's a strategy to try to engage that group of people. And so the crux of AOT is having a treatment system that's effective and evidence-based and intensive. And I'll talk more about what that treatment looks like. So how does it work? How do we make AOT happen? The law outlines a lot of the pieces of how the process works. First and foremost, there's a certain set of people who are able to make a referral for AOT. In California, that's essentially family members of somebody, people that live with somebody that's displaying symptoms, mental health provider of that person, or law enforcement. And then more recently, we've added judges to the list of parties who can make referrals. Secondly, the person has to meet a whole bunch of criteria that are also outlined in law. I'm not going to read through all of them, but I want to highlight a few of them. First and foremost, the person has to have a significant mental health disorder. And that's important to say because you cannot refer somebody to AOT due to their substance use disorder or their organic brain issue, their traumatic brain injury, things like that. So a diagnosed significant mental health disorder, essentially schizophrenia, schizoaffective disorder, et cetera. There also has to be the goal of AOT, and the legislation has a couple bullets that sort of describe what they're trying to get at with this, is really to find people who are in the process of declining. Things are getting worse. They're on the verge of not being able to be safe in community. And if we can get them into effective treatment now, we can avoid both more interventionist and restrictive form of care, and also potentially avoid harm to themselves or to others. So language is about persons unlikely to survive safely in community, or the condition is deteriorating, things like that. And so it's kind of a sub 5150, which is, that's a California reference, I guess. I'm not sure what it is in each of your states, but involuntary hold status, just underneath that status, trying to find that person before they get to that place. In addition, there is one area of the conditions that's very explicit, and the person needs to have been hospitalized 2 or more times in the last 36 months, or treated for their mental health needs in jail or prison at least twice in the last 36 months, or had a serious and violent act, threat, or attempt to harm self or others at least once in the last 48 months. Those first 2 bullets can be kind of restrictive, and it's one of the areas where we really narrow this population down a lot, at least in California. And then that third bullet, the serious threat of harm or injury, is a little bit more flexible. And I'll give an example of that. We got a call just this week from a family member, a mother of an adult child with serious mental illness. And he had been picked up on a hold, but she was calling to say, I think he needs AOT. And he didn't have a history of hospitalizations. He didn't have a history of incarceration, but his act was very significant. He pulled a gun on his mother and then held a very large rock over her head and tried to smash her head in, and she escaped and called 911. And so that's a situation where we're going to go straight to that third bullet and say, let's try AOT. Let's see what we can do to get this guy into a safer place. And then another really key condition, and I'll circle back to this when I talk about how the process works, is voluntary services have to have been offered and refused. And what we find, and what most AOT programs find, is that many people that we get a referral on, when we go out and start the process of engaging them and assessing them for AOT, when we start asking them about services that we offer and what they want, many people say, okay, that sounds good. And we can engage them in services that way. In part, this is because our team is super skilled at that relationship building and rapport building piece of outreach and engagement, and persistent, and we'll go back day after day after day and keep the conversation going with somebody. But it's a wonderful opportunity then to engage that person in care and just sidestep the whole AOT process altogether. And the law is obviously explicit about that. If that person engages, then there's no need for AOT or court orders, and we simply go down the normal voluntary treatment path. So once we've got the person, we've got the referral, and we've got the criteria met, how does it work? What happens? So essentially, if one of the designated people calls the Nevada County Behavioral Health Department and says, like that mom did, I'm concerned about this person, I want to make a referral to AOT. And then our staff does a kind of high-level screening to make sure that it sounds like they meet the critical criteria, especially they're located in the county, they're 18 or older, what is their history, and sort of a brief screening. And then if it feels like, yeah, this is something we want to look into further, we refer the person to our AOT team. And in Nevada County, that's a contracted provider called Turning Point. They provide our full service partnership, or ACT services, assertive community treatment services. They're co-located in the same building as us. We are very, very close partners. And so they're the ones that do our AOT investigations and services. And so we refer the person over to Turning Point, and then they begin the process of working with that person and going out, finding them and starting the conversation. And this is really, like I was saying a second ago, the place where having a high quality provider that's really skilled at connecting and building relationships is critical, because that's what they're doing right now. They're going out and trying to build rapport with that person and engage them in dialogue and try a lot of things to see, you know, what are your needs? What do you want? How can we work together? How can I support you in getting to a better place? And again, about 2/3 of people end up voluntarily engaging at that point, even if they've said no to services before. Just that concerted, regular contact outreach can lead to engagement. But if the person doesn't engage or doesn't agree to services, essentially our Turning Point, and this needs to be a licensed clinician, our Turning Point clinician completes the investigation and prepares the documents for our county council to bring a petition to the courts and to set a hearing. And a hearing happens. It can be a contested hearing or a stipulated hearing where the person agrees to enter into AOT and orders are written. If the person doesn't meet criteria, or in the hearing they're found not to meet the criteria, we'll continue to offer services, but the person may choose not to engage at that point. But if they do meet criteria and the hearing happens and orders occur, then we go forth and provide treatment. So what does that look like? What is assisted outpatient treatment, the treatment part of it? And this is a place where I really like how we've modeled AOT in Nevada County. So Turning Point, like I was saying, is our provider of our intensive services for our whole county population. So anybody in our county who has more complex needs, a serious mental illness, often other kinds of needs as well around housing or other life needs, needs that more intensive case management, care coordination, support, et cetera. We bring them into our full service partnership program or our ACT program. And so AOT is just another doorway into that same program. People who are in our AOT program are just another client in our ACT program. And I think that the fact that it's so integrated in that way and that there's no differentiation or stigma really around that designation really helps our program be highly successful, and also really allows our provider, who's deeply grounded in some core values around client-centered, strengths-based services, around a harm reduction approach, around a recovery, not just focus, but like deep belief in the possibility of and power of recovery, that those values can shine through even in a court-ordered program, because the program is larger than just that court-ordered element and really operates in this comprehensive, holistic way. So people in our AOT program, like others in our ACT program, have access to very low ratio care coordination or personal services coordinators who have caseloads of no more than 10 people. They have access to a psychiatrist, to a therapist, to flexible funds that we can use for housing supports or other things that might be needed. If needed, our Turning Point folks will visit somebody twice every day to deliver medications 7 days a week if that's what's needed. So it's pretty intensive supportive services. The thing that does make AOT a little different than how it works for others in our ACT program is the comprehensiveness of their treatment team. So in addition to all those normal players that somebody might have support from in an ACT program, they also have a whole legal system that's supporting them in their recovery journey. So that's the judge in the courts, the public defender, county council, law enforcement, Nevada County Behavioral Health. We're all engaged in that person's care and path and journey. And this is, I think, the place where programs can be super successful or it can be challenging. In Nevada County, we have really solid collaboration and partnership amongst all those different entities. And we've worked together long enough that we all trust that each of those entities, the judge, the public defender, the district, well, not the district attorney in this case, that's in our other courts, but county council, everybody is really operating from a place of compassion and respect and support for the person who is in front of them. And that culture and that value system permeates how the AOT court process works and therefore how the treatment team functions. And I think that's really critical. I think that if anybody on that team doesn't understand their role in that treatment process versus their role in a more typical punitive criminal court process, I think that that's where things can go sideways. And so deep training, a lot of conversation, a lot of education is really important for particularly the folks on that team who aren't typically involved in treatment processes with people with serious mental illness. We often bring clients who've been through the program to talk to our judge or to our legal staff and talk to them about what worked and what didn't work for them, and how they felt supported and when they didn't feel supported in processes, so that our team can all learn and do better over time. One thing I do want to touch on in the treatment part of the AOT program is the role of medications, because this comes up a lot in conversations, all different directions about the pros and cons of AOT. So there is not a provision for involuntary medication in AOT. And that's really important to underscore, because early on, when there was a lot of opposition to implementing AOT in California, that was one of the big concerns, is, very much about taking people's rights away and about forcing medications on people. And to be super clear, our goal is to not do involuntary meds and to instead engage this person in care so that they are not ending up in locked inpatient care where involuntary meds or the right to med decisions is taken away from them. So AOT is sort of a last ditch effort to support that person in their autonomy and right to make choices for themselves, for their body. And so instead, it's very much a gentle conversation about engaging with medications and the role medications can play in a recovery process for somebody. And 100% of the people that come into our AOT program are not taking medications at the time they come in, and about 98% end up taking medications during their time in AOT. And it doesn't happen in the first day or week, but slowly over time, as trust is built and as rapport is deepened and as the person feels more safe, we find that most people end up taking medications. And our judge plays a big role in that. The conversations that happen in the courtroom really go back and forth about, okay, what's comfortable for you? So you've taken that med before and you don't like it. How about this week, your job is to have a conversation with your psychiatrist about what you didn't like about that med and what other meds we can talk about. And similarly, the treatment team is having those same conversations. And again, over time, we just find that ends up working in ways that sometimes we don't even expect it will work. But really important to underscore that AOT does not include involuntary medications, and it does include a conversation about medications that typically does lead to people taking meds. I want to touch a little bit on the legal process, and I'm a social worker, not a lawyer, so this is not on the legal end of the legal process, but really more about what is the role of the court system in that treatment journey and in that road to recovery. And one of the things that I think is most powerful about how AOT can work is the role the judge can play in restoring a balance of power between the person in front of them and the service providers in front of them. And what I mean by that is, it's a unbalanced power dynamic to begin with. When you have, a medical provider or a mental health provider and a person in need of services, and that can be exacerbated very much by a, formal setting like a courtroom. But one of the things the judge does early on in our AOT process is speak to the person who's in front of them to say, you're here in an AOT process, but also Turning Point and Nevada County Behavioral Health are here. And my job is to come up with a plan for you that supports your needs and goals to get somewhere. And my job is to order Turning Point and Nevada County Behavioral Health to provide whatever it is you need. And he'll speak to us that way in front of the client. The client might come in and say, I'm really frustrated. I really want to try to get my driver's license and it's not happening. And the judge might turn to us and say, your job between now and our next hearing is to work on some steps to support this person in getting their driver's license, or whatever the issue is that's in front of them. And so I think it balances things in a way where the person starts to feel like they have some voice in what decisions are being made and what services they need and want, and that there's accountability to us to provide them. There's a lot out there about the whole concept of the black robe effect, and does it make a difference? Doesn't it make a difference? And I've had lots of debates with my fellow behavioral health directors in California on that topic. I think, like anything, it probably depends a little bit on the judge and how they use this opportunity. And again, I think because of the work we've done to build a culture of respect and humility, really, in our AOT process, our judges are really effective in engaging people in a different way than our providers might be. And there is something we find in the formality of a courtroom setting and the accountability of a courtroom setting that helps move things forward sometimes. I will also say it doesn't always work all the time, and we'll talk more about that in a second. The other thing we do is we use status hearings a lot in our AOT process, at the beginning particularly. A judge might have a person come back every week or once every 2 weeks for a little while until rapport is established and some traction is happening and we're making some forward progress. Over time, that certainly lessens, and near the end of the order, it might only be once a month that hearings are happening, or even less if things are going really well. But early on, we've found that having that regular contact and that sort of regular setting to sort of revisit, what are we doing here? Are we making progress? Are things going okay? Is everyone getting their needs met? Has been really helpful. And again, that's where we have a lot of those conversations about medications, et cetera. I want to share one example of a person who came through our process a little bit ago. He was somebody, he'd been on probation prior to coming into AOT. As probation was ending, the referral was made to AOT. And at that point in time, he was very volatile. He was very angry. He was pretty paranoid. He had little insight into his illness. And whenever he came into Turning Point, he almost always had to leave because he was screaming and yelling and getting very, very upset. And similarly, when he came to court, he was deeply agitated by the process, a lot of yelling at the judge, yelling at everybody, storming out. And a few months into the order, we actually had a conversation with the court about maybe we need to drop these orders. This isn't proving effective. And I think that's a really important point. AOT is only useful if it's useful. If it's not useful, it's not the right strategy for this person. And it seemed like it was kind of backfiring with this person. He was getting more mad from the court process versus seeing it as a door opening into a different way of engaging in treatment. And so at the status hearing that week, that conversation was had with him saying, all right, this doesn't seem like it's working. And let's give it a week to think about, but maybe we need to try something different and step away from this AOT process. And he left court that day and went home and called his personal service coordinator and said, I'd like a psychiatry appointment. And he came into the psychiatrist appointment a few days later, and everybody was like, what happened? What changed for you? And he said, just by the fact of everybody saying, we don't have to do this, made him realize he was fighting against something and he didn't need to be. That actually there was nothing to fight against. This was a team of people trying to be on his side, not create a barrier for him. And for whatever reason, just that taking away that pressure made the light bulb go on for him. And he, from that moment forward, honestly, which is a little bit unusual, just was deeply engaged in treatment and care, did super well, graduated from AOT, and then asked the judge if he could continue to come back and be a mentor to others who are entering into the AOT process. And he's continued to work as a peer mentor in that way. So it was, for me, it's just one of those examples of, for the right person in the right time and place, it can be a super effective strategy for just helping engage them in a way that we hadn't been successful engaging them before. So I'm going to talk for a second about some of the outcomes and sort of what we're seeing from our AOT processes. And this is where I'm going to get into a few numbers, but hopefully it won't be too much, not too detailed. So first, in the first 10 years of having AOT in Nevada County, we had 160 referrals for evaluations. And out of those 160, 79 petitions were written. So that means about half voluntarily engaged in treatment and didn't need petitions. And then of those 79 petitions, 42 were stipulated, meaning the person said, okay, let's just do this. And 15 were contested. So that's very few contested hearings over a 10-year period. And that the combination of those two things led to 57 AOT court orders over those 10 years. The average length of the order has been 180 days, but there have been a few times where we've done a second round of orders for somebody if we're making progress, but we're not quite there. And typically the person has agreed to that, and we've just moved it forward. Out of all those orders, we've only had to use hospital orders, which is sort of the one repercussion, I guess, if somebody's struggling in AOT and things aren't going well, we can use the AOT process to hospitalize somebody. And essentially in the same way as a 5150, a short-term acute stay, before a hearing happens and they end up being released, but a chance to just sort of short-term stabilize and address if things are going sideways in a short order. And so we've had to use hospital orders 16 times over the 10 years, so very rarely. And the average number of status hearings for each 180-day order is 11. So again, during those first 2-3 months, we're meeting once or twice a month, once a week or twice a month, depending on sort of the need of the person. And then later in those 180 days, we're down to once a month typically. And sort of in general, we have 5 to 7 people on AOT orders in a given point in time, which is very much aligned with the research out there that for 100,000 people, there may be 5 to 7 people who are eligible or appropriate for an AOT program. And that's really what we see in Nevada County. So what do we see in terms of outcomes? Well, because our AOT program is embedded in our ACT program, we see the same outcomes we see there, which is, highly documented and powerful. We see amazing reductions in hospitalizations, amazing reductions in jail days, higher employment rates, a lot less homelessness, and we see cost savings. And I think this is one of those slightly murky areas because it's one of those things where the savings are across multiple systems. So as the behavioral health department, we pay for AOT, for the treatment aspect of AOT, and it costs us about $25,000 a year for an AOT slot in our ACT program. And the research says there's about just under $2 saved for every dollar spent on AOT, but that $2 in savings doesn't come back to the behavioral health department. It comes to the hospitals and police departments and all the other places that are impacted when people are having a hard time being safe in community. In California, in Nevada County, we bill Medi-Cal for most of the AOT services that we provide. And then we cover things that we can't bill Medi-Cal for, and we pay the match for Medi-Cal with that Mental Health Services Act millionaire tax money that I was talking about earlier, as well as other state funds that we're able to get. So that is like my overall description. I guess I want to end with a couple of sort of overarching points about AOT and why I'm a fan of having AOT as one of your array of options as a community mental health provider. I know there's a lot of concern about ways that AOT can stigmatize people or criminalize people, and that's just not been our experience. For us, our goal is to serve people in the best ways we can, in accordance with what their needs and desires and wishes are for themselves, in respect of those needs and desires. And if it's at all possible to serve somebody in a way where they don't need to lose their liberties and be in more intensive or more intrusive care, we want to try that. And we believe people deserve that opportunity. And that's how AOT fits in for us. And so I think there's, one strand of concern about AOT that's really about the idea that it's too much of an intervention. It's too intensive. And that, why do you even need it? There's so many other forms of care out there. And again, for us, for some people who were having a hard time engaging, it's just a different strategy to try to push them through the door of engaging in care. And we find it effective with those people. But it's not for everybody, and it's not effective all the time. And that's really important to say clearly. And then on the other end of the spectrum, there's people that say AOT is kind of useless because it's not enough of an intervention. There's no teeth behind it. And I would say to that side, we have been really effective without those teeth, because really it's about outreach and engagement and relationship building and trust building. And often people who get referred to us on AOT aren't on our radar. Like the woman that I was talking about earlier who called this week, she'd been caretaking for her adult child at home, and he hadn't been hospitalized and he hadn't been to jail because she'd really shouldered the burden herself of supporting him with the care he needed to stay safely at home. As his condition deteriorated, he came onto our radar through the AOT process. And that happens often, or not often, but enough that it's a different doorway into our care, or to get somebody on our radar where we then can go out and do that outreach and engagement and relationship building. And again, often just voluntarily get that person into services and hopefully avoid a bad outcome for them or the community, and ultimately get to a better place with people and give people the resources and tools they need to move their life forward. And so I think those would be sort of my final closing thoughts. Is AOT fills a small gap in the system. It is not the be all and end all. It's not appropriate for all people always, but for that small subset of people who are having a hard time, things aren't going well, things are getting worse, there is some risk to themselves or others, it's an intervention worth trying, and often it will succeed. It is less restrictive than locked care, and it is very much possible to run an AOT program that is grounded in recovery-oriented values and that is client-centered and strengths-based and still works within that legal system. I deeply encourage you to build that team together, to work closely with your legal partners and your treatment providers and your law enforcement partners to understand the role of AOT and the treatment focus of it, and the role of everyone on that team in supporting that treatment outcome, and really deeply grounding your process in those values so that it's effective and not punitive and not hurtful to the person that ultimately everybody there is trying to support. And you can get to some pretty amazing outcomes with people, and people can really see the care around them and embrace that and take steps forward into a recovery journey that's pretty amazing to watch. And I'm grateful that we've been able to have this program in our community. And so with that, I hope that people will find a way to reach out to me if you have questions or if there's things I didn't address that you're interested in. But thanks for your time.
I went from partying in high school to doing some pretty hard drugs, hanging out with the wrong crowd. Ended up losing friends and family due to my addiction.
My dad went to prison and my mother committed suicide. My uncle adopted me and he sold pictures and videos of me into sex trafficking, and I felt like I didn't deserve anything.
I was so far gone that they didn't want me around. I ended up homeless and ended up having to detox in jail. And that's when I heard about Central City Concern.
I've been drinking for 50 years, lost a lot of great jobs, opportunities in life, and stumbled upon Central City Concern. They saved my life. They were the only organization to really reach out and make me understand the problem that I had.
I was about 6 months pregnant, and I learned about skills to be sober and to use in recovery, to be a functioning person in society, whether it be mental health, physical health, detoxing, breastfeeding, anything that I needed, it was all there.
I struggled finding a job. I needed to get a place to live because I've been homeless for many years.
I was a hazard to my family, but I got to come here, access the resources that were available.
Coming in broken and defeated, and little by little, finding my own self-esteem. Central City Concern played a huge role in helping me buy my own home. They guide us and mentor us and lead us into a life where we can help others.
Today I have keys to all my family's homes. I'm the first one they call when anything good or bad happens.
I have my own apartment. I drive my own car. I pay my rent. I have family back in my life. Life's really good for me right now.
Central City Concern is a place for hope for me to learn a new life, to be a healthy and happy person. And now I don't have to depend on anybody.
A second chance could be the chance that saves someone's life.
It's important for me to share my story because I'm proof that it works. I am valuable. Today, I deserve to have a life worth living. Central City Concern has saved my life. Sorry. It's still a big deal.
Thank God for this organization. They made me realize there's a lot more out there, I promise.
My movie until I got to CCC was a movie of pain, loss, hurt, and sorrow. My movie's ending with joy, happiness, support, and love. I went from being a hazard to an asset to my community.
Well, hello, everyone. My name is Jonathan Hereford. I live here in Jacksonville, Florida. What I'm going to talk to you today is about how the mental health system impacted my family and ultimately failed my family between my mother, my brother, and myself. My younger brother is Henry Sean Hereford, and he struggles with mental illness. I believe he's been diagnosed at this point with schizophrenia. A little bit backstory on him. We were both born in Scotland. Our mother was a Scottish native. Our father was in the United States Navy. He ended up meeting my mother over there, and we were born there, and we lived there for quite some time. Coming to Florida, his story is very interesting. He struggled with mental health issues since he was, I'd say, about 15, 16 years old. Unfortunately, I was in the Marine Corps serving our country at the time. I had no idea of what a Baker Act in Florida is called, but I think other states across the country call it like an involuntary hospitalization for mental health issues. Here in Florida, what that really means, somebody's going to be evaluated and held on a psychiatric hold for about 72 hours. And after that 72 hours, there'll be a determination made if that person needs longer care. So through these years, I've done my own research through medical records, police reports, incident reports, and I've come to the calculation that he was what we call Baker Act, or held against his will for a psychiatric hold for a total of 92 times. That's almost 100 times. As a family, we weren't allowed to know much due to HIPAA, which became an issue on locating him or even accessing help. Upon that, we didn't know what was going on behind the scenes. And what I mean by that is these facilities, the process seems very secretive in nature. He was being abused, not just physically, emotionally, sexually. Very hard to talk about sometimes, but at this point, I feel it's very important to tell his story as well as what ultimately led with him and my mother. So there's a couple instances specifically that I recall and remember that he would be released, but still needing psychiatric care. And I didn't understand until I worked in the system of what that means. Ultimately, he was out of insurance money. He still should have got treatment, but he didn't have any insurance, whether it was Medicaid or private insurance at that time. He was also on Social Security disability, and he's a victim of identity theft as well. So without having insurance, the facilities here in Florida decided, oh, we'll just kick him out on the streets. We might see him in a few days, but we need the bed space to somebody that can pay us. And I didn't understand that logic at the time, because if somebody still needs help, they shouldn't be just thrown outside. And what I mean by that, literally thrown outside, I saw him one day when I was driving to my mother's house. I was still active duty military here in Florida. I was going to my mother's house. She was having some problems with her apartment complex due to my brother being around trying to locate. He wanted to see his mom, but being psychotic, that's not very good for the community. Hallucinating, hearing voices, and just appearing not in your own right mind, but you can't get any help. I peeled off on the side of the road, exiting towards my mother's house, and saw a homeless man, or what appeared to be a homeless man, standing there, disheveled, long hair, wearing nothing but a bed sheet. And I didn't know until years later, until I could line up the timeline, that he had just been released within an hour from a psychiatric facility, naked, with no clothing. And I don't understand why we as a family couldn't be contacted to come pick him up, coordinate care, anything along those lines. But by the time I turned back around to see who that person was, he was gone. And I do remember just seeing his eyes and realizing that that was my brother. So that immediate next day, I went down to the courthouse here in Florida and attempted to, I didn't even know where to begin. You get no guidance because nobody can give you legal advice, but I knew I needed to be involved at some point in some fashion. So the best thing they could do was try to have him involuntarily evaluated again, and hopefully the facility of which he would be taken to would reach out to me. There was no guarantee that they would. There was no way for me to even know which facility he would go to. We had quite a few, like about 4 or 5 of the main facilities in our area. So I would have to go to each one and physically see if anyone would talk to me. It became a very burdensome task just because HIPAA. Nobody wants to talk about that. But there are provisions of HIPAA that allow individuals for continuity of care to talk to family members, which I think should be addressed. Because how can you help somebody if you don't know where they're at? But ultimately, this facility he was taken to did not reach out to me. So a couple of weeks goes by, I get this very, very horrific phone call that something's going on with my mother. And at the time, it was expressed to me like she may have been having a stroke or a heart attack. So I'm in uniform. At that time, I was on recruiting duty for the Marine Corps here in Jacksonville, Florida. So I go to the scene. I'm expecting, my mom's needing my assistance to provide first aid or whatnot, and that she's going to be fine. It's just a health scare. But when I get to her apartment complex, it's like a movie scene. Police everywhere. Things are taped off. And I'm just trying to even process what's going on. I just want to see my mother. So I talked to the police officer and they're like, well, first of all, you're in uniform. And I was like, I really don't care, but I had some gym clothes in my car. So I quickly changed so I wouldn't be on the news in my uniform. And I'm just like, why won't they let me see my mom? What's going on? Well, I didn't know it at the time, but my mom had already been deceased. And I was trying to figure out what is going on, like what happened, just like everybody else. Well, it wasn't until I overheard the police talking to the local news that my brother was involved. We said, we've got the son. That's all they kept saying. We've got the son. Everything's under control. But I was very, very, very confused when I thought my brother was in a psychiatric hospital. because that's what we did paperwork for a few weeks prior. So that day was the longest day of my life. And around 11 p.m., I'm sorry, the incident happened around 1 p.m. So around 11 p.m., so 10 hours later, I get a call from the state attorney to come downtown. They basically told me that my brother was involved and that they were going to charge him. Again, I had no idea what was going on, didn't understand the dynamics and the actual details, but that's what happened. So we get downtown, they tell me the details of everything that they're aware of, and that was it. Well, in Florida, much like I think in the rest of the country, there's different time limits, but if somebody is mentally ill and it cannot stand trial, they have to go to get competency training. Now, what I'm about to say is about 8 years worth of research when it comes to competency training. There's quite a few differences in the standard, and there's a difference between somebody parroting that information or actually knowing it and understanding it. So my brother was sent to a maximum of 5 years in the state hospital system to be restored to competency to stand trial. Now, that's without knowing any of the details of the incident that happened with him and my mother. But in this time frame, in these 5 years, he's been abused. He's been abused to the point where it's been physical, sexual in nature by the very own caregivers that are entrusted with, taking care of him and helping him be restored to competency. It's just pretty disgusting overall to kind of discuss, and I'm gonna try my best to give some examples, but it's things that are out of movies of what goes on in these facilities, and they're given complete access to do so because everything's kept in secret or confidential, as they like to say. Well, as a human being, not knowing everything that I knew about the court case, it was just to see him. How can we expect these individuals to get, one, competent, but two, to just live as basic human beings without, decency? We have the United States Constitution for a reason. A lot of the things that I've seen kind of violate that, but if you start reporting it, you get labeled yourself. And that's kind of where I'm at ultimately today. And I'll come back to that about being my brother's guardian and having that threatened because of me speaking out about it. The violence that he's experienced against him has been very tough to watch. It used to, I'd get a call or notification when he was hurt. They don't call me anymore. In fact, they abuse him when they know I'm coming to visit him because they know they can get away with it. It's just hard. It's hard to understand the kind of human beings that do that kind of thing, and that's not their position. Their position should be, at least in my opinion, to help these individuals restore, if they're in there for competency restoration, to be restored and be treated humanely. But unfortunately, what I've discovered is that this becomes just a dumping ground for these people that have mental health issues. And there's no proper screening for mental health issues versus traumatic brain injuries or any other neurological symptoms that could cause some of these issues that these individuals experience. So they just become lost to the system in a way. The families that I've met that have reached out to me, we all kind of have the same similar thread going on. And what I've noticed personally is if you don't agree with everybody, then you get labeled as a family member. And what I mean by that is if you don't do what everybody wants you to do, which means don't report incidents, do what the doctors say. As a guardian, I have a legal right to advocate for my brother, but also in Florida, we have an informed consent law, What do you do when the providers are saying, hey, put them on this medication, but I'm not going to answer any of your questions? Is it just do as I say, not as I do? For example, there's a medication that was in a lawsuit that lost due to males having gynecomastia. My brother was one of those victims of that. And he's being forced to be on that medication that has harmed him, even though there's been no clinical benefit of him being on it. It's just where do we have the conversation again of what's in the best interest of the patient and not the best interest of the state or of the judicial system? And that's kind of where I'm at. I've been threatened and currently being threatened of having my guardianship removed because I've been labeled as a hard person to work with, when I literally am just at this point printing out the law and asking and begging medical providers, judges, can we get back to the law? Because I really don't understand this. And this is kind of blows my mind. It's more still of a dictatorship. I don't know if you see behind me, that's my retirement flag from retiring from the United States Marine Corps. And we fought for those ideals, for the Constitution, for honor, courage, and commitment. And to me, those mean a lot. That's how I lived my life. And then these types of things happen behind our backs, and it's really hard to live with as a retiree, and how I move forward with my life. I don't think my brother will ever have his day in court, given what he was accused of doing, but it seems to me he's guilty. He's guilty in the fact that we don't want to presume his innocence. We're supposed to be innocent until proven guilty in America, but we're going to say people are guilty without giving them that. There's individuals that just won't get better, or they won't, I won't say won't get better overall, but just with the current regime, whether that is the system itself that can't evolve to offer more options to individuals. But here we are, 2022 and beyond. His first diagnosis of mental illness was in 2005. So we're going on, that's a lot of years, 18 years of the same type of medication regime that's not working for him. In fact, he's getting worse. So it's, where does that end as far as that ideology? And where can we start to think of different ways with our current technology? Or is he always going to be labeled this way? Am I going to be labeled this way for the rest of my life, for just actually wanting to get to the bottom of his mental illness, or at least attempt to, and help him have a decent life? Or are we just going to continue to hide all the abuses that he suffered? And he's never looked at as a victim, which it's mind-blowing to me. When we have, at this point, personally, we have videos. I've been on the news quite a bit in the media about it, but I think ultimately it's like, what does that say about us as humans? What does it say about us as our culture? A lot of big ideas to think about that are pretty tough to stomach some days. But, the system can be better. I think we can all agree upon that. And I worked in the mental health system for a while as a case manager, care coordinator here in Florida. But at that time, I was unaware that the same people I was working with were the same ones that had hurt my family. But what I can say is that we should work together. There is a way that we can all work together to help these individuals that suffer. Their stories really don't get told. I think we like to label people. Oh, that person's this, or that person just needs to take their medications. But what do you do when somebody's taken all their medications and they're still not better? Is it just continue and force that medication upon them? Where's their rights? Where's their constitutional rights? How can we balance this? I think it takes all of us to come to a table and sit down and kind of hash the things out that nobody wants to talk about. I'm always available for those kind of ideas. I understand now why other families, they reach out to me and they want to remain, I won't say silent, but they want to protect their identity. And I can see why. The last 2 weeks have been beyond stressful for me. Just listening to allegations made that are not true about myself causes a lot of stress for me and my family. Nobody should live like that. I believe in honesty and fairness, and I don't know how we bring that to this kind of system, if it's even possible. But I wish we could all just agree that this isn't working. What we currently have is not working, and I'm always available to sit down and talk. And I think there's a lot more families that are willing to do that. But the system itself, I think, doesn't want to admit that there's anything wrong. And I don't know why that is. But again, so right now, we've been to every state hospital in the state of Florida twice. Because what would happen as soon as I would report a victimization, they would magically move him instead of fixing the problem. And most of the time, they would move him further away from me so I couldn't see him or find out. Due to COVID protocols in our state, believe it or not, I really haven't seen my brother in the last 3 years, even though being his legal guardian. That's a whole different rabbit hole, but been limited access to him, limited access to medical records, and just overall limited access in general. Unfortunately, I almost died last year in a car accident, and I was given 3 days to live. And I can tell my wife and kids that I love them so much every day, and they know that. But for him, he would never know. And given 3 days to live, what hurt me the most was I tried to call, and they're like, "Oh, you need to call back when it's time for phone calls or whatnot." And I could have never talked to him again, and he would just think I'd forgotten about him. And I still carry that with me right now. It's just the inhumanity that I've experienced, watching him go through. And ultimately I carry my mother's strength. My mom saw it way before I ever did, because she lived it when I was in the Marines trying to get my brother help. And I think I can connect my brother with doctors that could probably help him, but the system here in Florida anyway is just trying not to let that happen. But I know we're getting close to time there, but I just want to appreciate everybody listening. I hope my family's story can just probably provide you a little bit of insight on what's going on in America here with the mental health system, and we need to change this thing. It's well overdue. People are still struggling. We can do better. If you ever need me, I'm always available. And thank you for your time.
Well, it's my pleasure to be here today at the Law and Mental Health Conference to give a historical account of how Washington's sex offender commitment law, the so-called sexually violent predator law, was put into place and what happened to it when we tried to stop it. Before the Supreme Court ruled on it, we had a series of articles in the Seattle University School of Law review, including one of mine at the very bottom, and one from a friend of mine, colleague John LaFond, in what he called a deliberate misuse of the therapeutic state. This was mine, Nightmare in the Halls of Justice, inspired by Kafka's The Trial, because these clients who were prosecuted had done nothing new wrong. They had been punished for their crimes, and in one case, Mr. Cunningham was out in the community for several months, and the other, Mr. Young, was going to be released from prison the next day. These cases show that one or two judges can make a huge difference. When we went to the Washington Supreme Court, the court decided in a 6-3 decision, I think one that surprised even the prosecutors, that the sex predator law was constitutional. They reversed Mr. Cunningham's commitment because they did several things to find that the law was constitutional. One of them was to require a recent overt act if you had been in the community, which was something that normally is considered in a civil commitment law. They said that that did not apply to Mr. Young because he was in prison. The court described the Community Protection Act as responding to citizens' concerns. This was definitely the case. It was like a railroad train running through the legislature at that time, and there just was not any real opportunity for people to think about the long-term consequences for a justice system of locking people up who had not done anything new. This U.S. Supreme Court had said that to be locked up in a civil commitment, you had to be mentally ill and dangerous. The Washington court said this was just fine because mental abnormality covered a large variety of disorders, and that there were mental health professionals who said that was just fine with them. We had mental health professionals who said this is bogus, but we didn't win. And they said no recent overt act is needed if you're in prison, but if you're out in the community, then there needs to be proof of recent overt act. And since there wasn't, they reversed Mr. Cunningham's case. And also Mr. Cunningham had a non-unanimous jury, and the court found that that was a requirement as well. The court also said, you know, it's a problem under this statute that there's an initial probable cause determination without an opportunity for a hearing, and that's terrible. There's a risk of wrongful detention, but it didn't happen in these cases, so it's harmless. But from now on, it has to happen. But since these guys were convicted at trial, too bad. It's not a problem for them. We also said, hey, you know, there's an equal protection right to consider less restrictive alternatives to confinement, and that's what our regular civil commitment statute does. And the court said, hey, yeah, you know, that's right. And so we're going to reverse Mr. Young's conviction just to remand on the consideration of less restrictive alternatives. He's still a sex predator, but he can consider alternatives to confinement. And there has to be a 12-person unanimous jury. Again, the court just added this into the statute on its own by saying that proof beyond a reasonable doubt means a unanimous verdict. I think those are two different things, but the court said that they were the same. In Mr. Young's case, many years earlier, he had been a college student and convicted of a bomb threat on campus. This came into evidence against him at trial over our objection, and the Supreme Court of Washington said that was harmless too. Shouldn't have come in, but it was harmless. So they said that the statute was civil. This turned out to be a very crucial finding when the case went to the U.S. Supreme Court. And so there were no substantive due process concerns in the case. And there were these little problems like the 72 hours and so forth, but those are harmless. Mr. Cunningham was reversed and the state never tried to prosecute him again. And although it took a week, we got him out of custody and he was able to go home. There was a strong dissent by Justice Johnson in the Washington Supreme Court. He basically said that indefinite commitment of people that are not mentally ill threatens all of our liberty, not just the people that are being prosecuted, and that's what this was, that these folks were not mentally ill and this was a dangerousness court. And he said that this was a grave error in setting up special class of people that can have fewer rights, and that the statute was a preventive detention scheme based on allegations of future dangerousness. Signed that opinion. Had there been two more, the statute would have gone away. The way he described it, the statute authorizes holding someone forever for the good of the community based on one sexually motivated crime, no matter how long ago it was. And we would be better off by adhering to constitutional principles. He said that the statute is based on fears of future crimes, and it offends ex post facto law and double jeopardy law by masquerading as a civil commitment law when its purpose is penal. He called it punitive in purpose and effect. That phrase was very important as the case went forward in federal court as well. So then we filed a federal habeas corpus, and one of the great moments in my career was getting in a phone booth, finding out that the district court had found the statute to be unconstitutional because it violated everything we said it did: substantive due process, ex post facto, and double jeopardy. If a statute pretends to be civil, but it's criminal in purpose and effect, then as applied in this situation where the law was passed after Mr. Young was already in prison, punishing him again for what he did before is double jeopardy, and the statute is ex post facto. It's passed after the incident that led to him being locked up. But even though we won in federal habeas, the state appealed, and it went to the Ninth Circuit. But by the time the Ninth Circuit got to deal with it, the U.S. Supreme Court had decided a similar statute from Kansas in a case called Kansas versus Hendricks. And they said that the law was just fine. I did a friend of the court brief in that case, but didn't prevail. In this case, one judge made a difference. It was a 5-4 decision saying that the statute was okay. Justice Kennedy filed a concurrence, and Justice Breyer, Justice Stevens, Justice Souter, and Justice Ginsburg all dissented from the Supreme Court of the United States decision saying that the Kansas law, which had mental abnormality as well, was just fine. Justice Kennedy said, let's be careful. If the civil system is used simply to impose punishment, then it's not performing its proper function. And we should bear in mind that this is a concern. He said that on the record we have, Kansas conforms to our precedents. But if civil confinement were to become a mechanism for retribution or general deterrence, or that mental abnormality is too imprecise a category, then it would not be okay. The dissent, led by Justice Breyer, and of course, you know, most of these justices are gone now, but and all of the dissent are gone. Inadequate treatment is what the issue was, both in our case and in Kansas, that we were saying, hey, these guys are basically in a prison and they're not getting treatment that even comes close to being real treatment. And so the dissent in Kansas said, then it's punishment, and you can't punish the person with a law that's passed after the act. So the Ninth Circuit, when it got our case back, said, well, you know, let's go back to district court. And we went to district court. We didn't get anywhere. We went back to the Ninth Circuit. And in the Ninth Circuit, we talked a lot about the treatment problem. There wasn't real treatment. When this law was passed, our clients were held in the prison in Monroe, just in a different part of the prison. They didn't even pretend that it was a treatment facility, really. They eventually moved them to McNeil Island, which was an even more remote prison. And so what the Court of Appeals in the Ninth Circuit said about our case is, if the petitioner, Mr. Young, can prove what he says about the punitive nature of his confinement, then the law does violate ex post facto and double jeopardy. So we're going to remand this to the district court to have a hearing on that. Well, we never had the hearing on that because, and they said it had to be by the clearest proof. And we never got the hearing because the state sought review in the U.S. Supreme Court, which granted it. And 8-1, we only got one justice, Justice Stevens. The U.S. Supreme Court said that it was just fine because of what they had said in Kansas, which was a 5-4 decision. And they relied on the Washington Supreme Court saying that the law was civil in a 6-3 decision. I think the U.S. Supreme Court really misunderstood what the case was about, and I'll talk a little bit about that here. They said that Mr. Young could not obtain release with an as-applied challenge to the Washington law. That in effect, the Washington Supreme Court had said it was a civil case, and so we can't come in and say, well, he's being treated badly, because the treatment of one person, according to the U.S. Supreme Court, isn't going to invalidate the statute. And because confinement goes over time, it can't be an as-applied challenge. It has to be what's going on for the system as a whole. And they disagreed with Justice Stevens because the Ninth Circuit had said the law was civil. The Washington Supreme Court said it was civil. And so we didn't get to argue, or we didn't get to prevail on the as-applied challenge. It's unfair as applied to Mr. Young. And they said the Ninth Circuit was fundamentally flawed in using an as-applied to Mr. Young analysis. And they said, but don't worry, because we know that the Washington law says that you have the right to adequate care and individualized treatment. And if it's not happening, well, you can always sue. And as a matter of fact, we see that you are already suing. And we did have a 1983 action in federal court in Washington. And there was an injunction to the state that they had to adopt and implement a plan for training and hiring competent therapists. It was really a disgrace, the way the state implemented this flaw and the failure to provide real treatment for many, many years. And the U.S. Supreme Court noted that there's a special master in federal court bringing the center into compliance. The district court had noted some progress. They hadn't met the requirements. There was some progress. So, leave us alone. And so this this language is what really surprised me, because nobody had said anything about a first instance challenge. Nobody knew what a first instance challenge was. But the court said, we're not going to consider how the civil nature of a confinement scheme relates to due process challenges, or to the extent to which a court may look at actual conditions of confinement and implementation of the statute to determine in the first instance whether a confinement scheme is civil in nature. Well, this was the first instance. This was the very first case. It was the very first case to go to the Washington Supreme Court. It was the very first case to go to the U.S. Supreme Court about this law. So it was the first instance, but they were saying, you didn't raise it in the first instance, and we're not going to address it because this somehow wasn't the first instance. Justice Scalia said that conditions are irrelevant unless the state court has interpreted the act as permitting those conditions, which of course the legislature didn't say. You can pretend to have treatment and lock people in prison. They didn't say that. And of course, Justice Stevens says you have to consider conditions to understand the full effects of the statute. Supreme Court majority said we've not squarely addressed the relevance in the first instance. We're not going to resolve it here. It cannot be deemed punitive as applied to a single person in violation of double jeopardy and ex post facto. And so we're going to reverse it. We thought we were in the first instance arguing due process, but they didn't think so. So Justice Stevens says the conditions of confinement are evidence of the purpose and effect of the statute, and it was punitive in its purpose and effect if Mr. Young can prove everything he says about the punitive nature of the prison that he's being held in and the lack of treatment. So Justice Stevens says, okay, the majority says that confinement is not a fixed event, so you shouldn't consider it, except in the first challenge to a statute, when as a practical matter, the evidence of such conditions is most likely not to constitute clear as proof because they just began it. We, of course, had already developed lots of evidence about the lack of treatment and the punitive nature of the confinement. And then in many ways, Mr. Young had less privileges than had he been a prisoner in the regular prison wing. And we thought we were in the first instance when nobody even knew what the first instance meant before this. And so Justice Stevens says, if the conditions are such that the detainee has been punished twice in violation of double jeopardy, it's irrelevant that the scheme has been previously labeled civil without full knowledge of the effects of the statute. In other words, the Washington Supreme Court said the statute was civil because before they had full knowledge of the effects of the statute and the punitive nature of the facility and the way they were being treated. And so Justice Stevens said, it is very relevant what's going on, and we should consider it. And the detailed allegations about the absence of treatment for his alleged mental illness and the starkly punitive character of the conditions of his confinement, if proved, then they're getting worse treatment than if they were criminal prisoners. And the law should be characterized as criminal. And so Mr. Young should be given the opportunity, as the Ninth Circuit said he should have, to come forward with the clearest proof that his allegations are true. That never happened because the Ninth Circuit sent it back to district court, and we got nowhere in district court. And the Ninth Circuit said, you know, the statute's civil, and you don't get to argue that anymore, and we think it's civil, so go away. A couple of years later, Mr. Young went back to the Washington Court of Appeals. His case had been stayed because of other cases that were pending concerning the condition of confinement issues. He had a couple annual reviews during that time. There were a lot of issues raised. The court affirmed the lower courts and gave him no relief. But after 20 years, literally being locked up in prison, in the so-called predator treatment program. He was released finally in 2010 at the age of 69 to live quietly in Tacoma. I thought I would review this little chart that was made by King TV, because it really addresses what both the Washington Supreme Court and the U.S. Supreme Court just were not willing to look at. In 1994, the federal Judge Dwyer, may he rest in peace, ruled the Special Commitment Center was too much like a prison, and he fined the state $11 million. The fine was later dismissed. This case went on and on and on. In 1999, the state was found in contempt of court because they didn't do some of the things the court had ordered them to do. In 2004, the state spent $61 million to build a facility on McNeil Island for civilly committed sex offenders. Before that, they'd been held in Monroe and then in a prison on McNeil Island. We were in the U.S. Supreme Court in 2000. So it wasn't until 2004 that they built a facility to so-called treat, and they spent an unbelievable amount of money. 2005, they opened halfway houses for residents who could live in the community, but one of them was on McNeil Island. And of course, you have to get a ferry boat to get off of the island. And it wasn't until 2006 that the first resident moved into one in Seattle. In 2007, Judge Martinez lifted the injunction that Judge Dwyer had imposed 13 years earlier. So it took 13 years for the state to overcome the deficiencies. And all that time, people were locked up. So I was asked to address how all this relates to the change in sentencing in Washington for sex offenders. It used to be, when I started practicing, everybody had indeterminate sentences. So you'd be sentenced to prison for the maximum term, and the parole board would decide when you get out. Then in 1984, we had the Sentencing Reform Act, which required presumptive and determinate sentences. So the judge would say, you got 48 months. And the parole board was going to go out of business, but the legislature decided, you know, we're not so sure about the sex predator law, how it's going, and we want to do more control of what happens to sex offenders. So we're going to change the parole board to the Indeterminate Sentence Review Board, and we're going to make some sex offenders, most of them, subject to it. And so the court shall impose a maximum term and a minimum term. So we went back to what we had done before 1984 for sex offenders. And so they then get a maximum term, which is the maximum statutory punishment. And then the ISRB decides when they can go home. So before that, before this change in the law, the ISRB was pretty much just dealing with people who had been sentenced. Everybody after 84 had a determinate sentence. Excuse me. And so the ISRB has three types of cases: people before 1984, sex offenses, and then these youthful offenders that the U.S. Supreme Court cases and Washington Supreme Court cases have allowed to have new review. So the review cases conduct hearings. If somebody gets out on parole and then they have a violation of their conditions, and there's a hearing about that. And so that's what, and the way the ISRB in its annual report describes their board, they say they were revitalized when the legislature passed this new law about sex offenders, bringing those cases under the jurisdiction of the ISRB. And according to the ISRB, what this does is provide consistency of sentencing combined with a mechanism to address cases where likelihood of sexual recidivism was high. The new model provided for ongoing community supervision for people that are allowed out, and the ability to add conditions in addition to those imposed by the court at sentencing. So if the parole board says, well, we can let you out, but only, the ISRB, we can let you out, but only under these 3 conditions, which the sentencing judge never thought about, they can add that on. Whether that's good or bad, I leave for other people to determine. So the history of this law raises really disturbing questions about fairness, allocation of resources, the distortion of mental health treatment. In one of the cases, the state presented to the judge at the beginning of the case a report that the psychologist had done for the state. This was a psychologist who was hired by the state. He had never met the client. At the very same time, the client had been getting treatment and evaluation by a psychologist in the prison who was asked by the prosecutor, is this client a sexually violent predator? And the answer was no. Well, when the prosecutor presented the case to get the client arrested under this new law, the so-called predator law, the prosecutor gave this hired consultant who never met the client, gave his opinion to the judge, but did not give the prison psychologist's opinion to the judge, who said that the client was not a predator. That's the kind of unfairness and distortion of facts that this law was built on in its initial several years of implementation. And it's really a dark side, I believe, in our state's treatment of folks under the fear that someone's going to commit a crime in the future. When they've already been punished in prison, they haven't done anything wrong in prison, and they have a plan to live their life when they get out. It's just it's really an unfortunate chapter in our state's history. I wish I could take questions, but this is a recording, so I cannot. But thank you very much. I appreciate the opportunity to talk with you about this law and how it came about. I understand that one of my colleagues is going to be speaking to you about what's been happening in the past few years with this law, and look forward to hearing about that. Thank you again.
Just like any hospital, our goal is to help people get better and return to their lives in the community. We provide the highest level of psychiatric care in the state and serve people from all 36 counties. Welcome to Oregon State Hospital. Our vision is to inspire hope, promote safety, and support recovery for all. We offer treatment that helps patients build on their strengths, stabilize their symptoms, and develop skills to successfully transition to life in their community. Oregon State Hospital has 2 campuses, one in Salem and one in Junction City. It's here where our patients engage in treatment and begin their journey to recovery. At the hospital, patients stay in a living unit with 20 to 30 beds. They will have either a single room to themselves or a double room with a roommate. Compatibility is considered whenever possible to ensure the safety of each person. Most patient rooms have their own bathroom. The hospital offers 3 meals and an evening snack each day, with a variety of healthy and nutritious foods to choose from. Patients eat most of their meals in a dining hall near their living unit. The dining halls and cafes are also where most patients visit with their friends and family. Visits are welcome and encouraged, as friends and family play an important role in a patient's recovery. Each unit has treatment teams with a psychiatrist, nurse, social worker, psychologist, and most importantly, the patients themselves. The treatment teams collaborate with patients to develop individualized treatment care plans. Patients may also invite friends or family to be on their treatment team. Patients meet with their team members regularly to create and update their treatment care plan. The plan guides the patient's treatment activities, medications, and other therapies. The treatment mall is the primary place where patients engage in treatment. Set up like a college campus, the treatment mall is where patients attend classes and therapy groups. These groups help patients develop the skills they need to manage the symptoms of their illness, move toward wellness, and prepare for a successful discharge back to the community. Patients follow their treatment care plan to decide which groups will help them most. Examples of treatment mall groups include medication management, legal skills, and classes that teach daily living skills like cooking and shopping on a budget. A psychiatrist or nurse practitioner may prescribe medication as part of a patient's treatment. Staff will help patients stay on their medication schedule. To help with their physical health, patients may go to an on-site medical or dental clinic. Physical therapists and other specialists are also available to treat patients' medical needs. The hospital offers plenty of activities during the evenings and weekends. Patients play games, watch movies, go to the on-site library, attend open mic concerts, or play basketball or volleyball in one of the gyms or outdoor quads. If patients need clothing, they may request items from the hospital's 2 clothing shops. We have seamsters to help hem pants and mend favorite shirts. Many patients also use a hair salon on campus to get a haircut or style. Some patients can apply for a variety of paid positions throughout the hospital, including coffee shop baristas, greenhouse attendants, cashiers, and furniture makers, to name just a few. By having a job, patients learn important skills to help them find employment after they're discharged. They also learn how to manage their own money. The hospital encourages patients to pursue their educational goals, such as earning their GED, graduating from high school, or taking college courses. The hospital's supported education department matches patients with the program that best meets their needs and interests. Some patients also participate in community outings, such as going to a coffee shop or the grocery store, to practice the skills they need to successfully transition back to their life outside the hospital. In collaboration with our patients, we are partners in wellness. We provide patients with the treatment they need to lead successful lives in the community.
Hi, my name is Shoshana Kehoe Ellers, and I'm coming to you from Olympia, Washington, from the Washington State Office of Public Defense. I'm here to present on the Washington State Revised Code Statute 7109, also known as the Sexually Violent Predator Statute. So I am going to be picking up where Bob Berkowitz, who was just before me, ended. And Bob did a really good job explaining the evolution of this law in its early days when public defenders were challenging it, because it is really it's illogical to have to, in a sense, be resentenced to a term in a hospital. And the way it was back then, all the way probably up until about 2010, 2011, is you either won your initial commitment trial, which is a big, big deal. Lots of work had to go into it. Or if you were committed by a judge or jury, you would then, there was really no way out. So you would just die there. And that honestly became a huge fear of a lot of patients as they aged there, that this was where they were going to die. And that's because, as Bob said, this was much more of a correctional punitive system method of dealing with folks that they thought were 51% likely, more likely than not, to commit a sex offense in the future. And as you can imagine, the research and everything that has evolved around then has been a little kind of questionable, because trying to predict what somebody is going to do in the future it's impossible. I mean, it just is. So once it was clear that after the cases had run through all of the different court systems, state court, federal court, the US Supreme Court, it was clear that this was going to have to be a statute that was going to have to become workable. What was going on at around 2007, 2008 is we were starting to see either private, what's called, after a person is committed, and they were doing treatment, and the treatment team started seeing that, they could probably be out in the community, or not probably, they could be out in the community without there being a significant risk that they would reoffend, and that they could be out in the community with adequate protection factors for themselves and for the community. The problem is that there was no housing, and not just no housing, but that there was no infrastructure around what this individual was going to do in the community. So as Bob had mentioned, under a federal decree, because the Special Commitment Center was not providing treatment or avenue to leave the Special Commitment Center and actually make it out, then they became under federal decree to improve that. And part of that was to build 2 secure community transition facilities. And that's what Bob was talking about, like halfway houses. One is on the island, the McNeil Island, where the Special Commitment Center is. And one is in King County in the industrial district, also called Soto, which is where, where the sports, Seattle Mariners, and where that whole area is. It's pretty industrial. And they're a lot more than just halfway houses. There's barbed wire around them. There are cameras everywhere. Individuals cannot leave without permission, and they have to be able to do kind of point to point, where they call their community corrections officer, and then when they get to their destination, call them again, and when they get back to the facility, call them again. And that's about all they could do. Was when you're in the SCTF, you're able to go see your community treatment provider. And if you're, fortunate enough, you could maybe also do some trade school, some community college, or work, really. That's what, for those that are able to, for being able to secure employment so that they can, be able to take care of themselves once the civil commitment process is finished. So let me just back up a little bit. So that's how the Pierce and King County SCTFs happen. So there's just those two. But these individuals come from all 39 counties in Washington state. And I think a lot of that had to do with, yes, they had to build these SCTFs, but there wasn't a feeling that this was actually going to go any further than that. Although we did start to see in 2008, 2009, 2010, individuals being able to be released to private residences. So essentially what that meant is if the individual had family and they would be able to go back and live with them, that would work. But other than that, there was nothing where the individual could go other than the SCTF. So my office, the State Office of Public Defense, became involved in this back in 2012, so 10 years ago. In Washington state, as you may know, public defense is decentralized. It's not a state system. It's county by county, city by city. And so, being able to ensure that the individuals who were being represented by defenders who had the background in civil commitment was really tough. Our bigger counties like Spokane, Snohomish, Pierce, King, they had a fairly robust public defense system that was able to, understandably, take on these cases. But outside of that, most of the time, these cases were assigned to an individual that had a regular general practice caseload or a criminal defense caseload. And so while they were doing things that were on much quicker timelines in 7109, these cases sort of hit the back burner. And they were assigned just, the most way that cases are assigned around Washington state in the non-bigger counties is a judge might assign them, or some sort of small, public defender office would assign them, but not looking to see if they had the requisite experience. And so what we were finding is when OPD took over in 2012, is that there looked like there was probably about 40 to 50 individuals that had been there for over 10 years at the Special Commitment Center and had yet to receive their first initial commitment trial. So once probable cause was found, they were sent to the SCC. They sat there for sometimes a decade. Because of what Bob had shared with and the CLE, that the issues were so significant and they were litigating constitutional issues that things wouldn't move at any kind of reasonable pace. Plus, the Special Commitment Center was not in the business of treatment and trying to provide the treatment environment that the individuals needed for them to be able to begin the step-down process into the community. Understandably, there was not a lot of support for this. DSHS is an enormous agency. It was the legislature that came up with this law. And so clearly they wanted to be able to, hang on to these folks because of the fear that the public had. But once the federal monitoring started, it became clear that you just can't neglect these individuals because they're there for a purpose. And if they don't meet what's called the criteria, which is also the statutory definition of what's called a sexually violent predator, then they can no longer be held. They can no longer be held in total confinement. They can no longer be held on a conditional release, which is also known as a less restrictive alternative. And the reason they call it less restrictive alternative is because The total confinement center, which is on the island, is a complete lockdown. Less restrictive, which is also something that's used in other areas of our mental health system, such as Involuntary Treatment Act, not guilty by reason of insanity individuals, that those that you have to be able to have a path out. That's basically how all of these statutes are allowed to be constitutional, especially when it comes to 7109, because you have already served your prison or your jail term. So there just seemed to be kind of a lackadaisical approach to all of this. Now, when OPD took over, we were able to contract with a group of contractors across the state that had expertise in this area. And we primarily made it that you had to exclusively practice this in 7109. That significantly changed things in the first few years because the attorneys, social workers, legal assistants, investigators were able to push cases that had been sitting there for decades out, getting them moving, having them dismissed if there really wasn't the criteria, or if they had been in treatment for a while, having them petition for an LRA. In Washington State, the way the statute is the secretary, the hospital can recommend that the person either, one, just be unconditionally discharged because they no longer meet the definition, or two, they meet the definition, but it's within their best interests to be on a less restrictive alternative, and there are adequate public safety and measures to protect the community. Once that happens, then you can start petitioning for an LRA, and that's when the litigation starts. Because in the beginning, the state, there's two state actors here. There is the Special Commitment Center, which falls under Behavioral Health Administration, which falls under DSHS. And then there's the state that does the prosecutions of these civil commitment cases, and that's handled by the Attorney General's office, except in King County, where it's handled by the King County Prosecutor's Office. And the reason for that is that all the counties, if they chose to, they could prosecute these civil commitments. But because they are such a resource-heavy process and requires expertise in the area of risk actuarials, peer review studies, all sorts of stuff, statistics, understanding the DSM-5, being able to read peer-reviewed studies, being able to score risk actuarial tools and cross-examine experts who have a ton of background in this area to be able to do that. So once the petition was granted, or once the case was set for trial, then the process really started. Do we have a sex offender treatment provider that's going to be appropriate for this individual? What about housing? What about, location? What about making sure that victims and other types of, neighborhoods and things like that are not going to become too much of a challenge for the individual to live in? So a lot of that went on for several years once something was set for trial. Majority of the time, the attorney generals and the defense attorneys would negotiate a less restrictive alternative, but it took an enormous amount of work because the statute said that the defense was entirely responsible for putting an LRA together, which means we had to find the housing, we had to find the sex offender treatment provider, all of this stuff. Now, because defense, we don't have any access to paying for the housing, that is handled by DSHS. And because we don't know where everybody resides and what's going on in that area, we could only do it case by case. So what ended up happening is, well, let me back up one thing. So the early days of when OPD took over and the defense attorneys were really litigating these cases hard, things started moving a lot faster, I think, than the legislators wanted and the prosecutors and the community wanted. But it was something that had been a backlog for over a decade. So the issue was being forced. These individuals were moving into the community. They had to move into the community. They had orders saying that they should be released. And sometimes these people were just sitting there, especially the individuals with intellectual disabilities, traumatic brain injuries, dementia, high acuity mental health, wheelchair users. None of them were able to get adequate housing and other types of services to be able to be successful on an LRA. That's when Disability Rights Washington entered. 2014, they started investigating. In 2015 and 2016 was when, actually 2015 was when the articles started coming out talking about how poorly these residents were being treated, how they were being warehoused despite the fact that they're not supposed to be. People were dying on the island because they live on an island as opposed to close to any hospitals. There was never adequate medical care. There's still a lot of problems with that. The only way you could get off if you had some sort of major medical issue was to be helicoptered off. It also was costing up to $200,000 a year to house these individuals. Because again, they're on an island. Everybody has to take a ferry out to the island, including defense attorneys. And the staff that work out there, they are not compensated for their transportation to get out there and back, only for the time that they're on the island. As far as I know, Washington State's the only one to have a special commitment center like this on an island, which makes it exceedingly difficult. It puts up a lot of barriers, and it just makes it difficult to be able to work with the individuals and ensure that they're doing okay because it's such a trek to go see them. So after Disability Rights Washington filed a complaint, the Special Commitment Center quickly entered into a federal settlement agreement, primarily to ensure that there's a high acuity wing and that there's conditional release housing, a pathway out for individuals with disabilities. This was really starting to kind of help pick things up, and we started seeing movement. But then, of course, with movement, the counties that had these less restrictive alternatives, housing and infrastructure, were very few. It was just Pierce, King, a little bit, not much, Snohomish County. They were the only ones with housing. And it made sense because the Pierce County Secure Community Transition Facility and the Total Confinement Facility is in Pierce County. They have the infrastructure. King County as well, that special commitment, that Secure Community Transition Facility, it's hard to do much of anything since it's in an industrial district. So what started happening is the attorneys started just going directly for community LRAs, less restrictive alternatives, because the statute permits that. And so as of this point, I think we have well over 70 individuals in the community. There's a total of 230 plus individuals under the jurisdiction of 7109. So as you can see in the last decade, the system has really moved to getting people into the community as quickly as possible. Now, for many of these individuals, that can't happen quickly, but there are things like adult family homes that are really providing the care that those individuals are going to need, because they're always going to need to have some type of round-the-clock care. But the other individuals are really going to benefit from the step-down process, because as you can imagine, after they've served a long prison term, it's been decades since they've been out in the world. Many don't know how to operate a cell phone. Things have really, really changed. And it's scary because you kind of have a target on your back. You do have a target on your back when you are a sex offender, when you're a level 3 sex offender, which is the highest level in Washington state, and when you have the label of a sexually violent predator. Now, back in the day, before indeterminate sentencing, which is something that Bob mentioned, and I think that started in 2002, the folks that you were getting in the 7109 were not necessarily the folks that you see now. There were individuals that had committed serial offenses. It was less a mental health issue and more of a mental disorder, like psychopathy. I mean, not psychopathy. Psychopathy and antisocial personality. But as the indeterminate sentencing law caught those individuals were now held back in prison in DOC and become part of the jurisdiction of the Indeterminate Sentencing Review Board, which is sort of took over what our parole board is. So you have to serve when you're on the inside in the prison, you have to serve at least, generally they hold you until your max date. But those individuals are often the ones that they're not so much dealing with mental health as dealing, I think, with much more significant public safety issues. So indeterminate sentencing has taken that population out, and a lot of who you see now in 7109 are individuals with disabilities. You also see young people, very young people, who essentially from day one, were in foster care or in juvenile rehabilitation. Just things are so upside down. So as these people are beginning to get out in 2017, the issue of where these people were going to go became a huge issue for legislators and the community. There was a statutory amendment that said that you had to try to go back to your county of commitment, which is also the county where your underlying conviction was. This presents all sorts of problems because there's only a handful of counties that have resources necessary for individuals to be conditionally released. Also because of victims, all sorts of stuff. Many, many, many counties in Washington state don't have any kind of infrastructure. Let's see, but I guess to say about, so the county of commitment issue, because Pierce County was getting most of the individuals that were coming from all across the country, all across the state, excuse me. And they were really upset about it, understandably. So there was an amendment done that you need to try to get it in the county of commitment. Within a year or two, it was clear that that was not working. And so in 2019, a number of interested party stakeholders came together: Disability Rights Washington, prosecutors, attorney generals, legislators, defenders, sex offender treatment providers, Special Commitment Center, yeah, you name it, they were there. So we worked for several years to try to get at how is this going to work? And what came out of it was in 2021, what came out was we're going to have a fair share standard, not a county of commitment, which means the individual goes to, if they can go back to their county of commitment, fantastic. If they can't, then they need to go to a county that has the appropriate services for that individual. And at the time, several years ago, like I said, there were only a handful of counties that had these resources. And so the legislature and the other interested parties started to understand that building the infrastructure needed to happen through DSHS, the Special Commitment Center, because they have the resources, they have the funding, and they have the ability to take a look and see where are people being placed. So the fair share thing has to do with, for example, in Kitsap County, that county has approximately 30 individuals that are under the 7109 jurisdiction. So that means they should be able to take back 30 individuals through less restrictive alternatives or unconditional discharge. Doesn't have to be the same Kitsap County individuals, just needs to be somewhat proportional. So that is why there was a big shift. And it's only been a couple of years that this has been going on. In fact, it's so new that in 2021, the Sex Offender Policy Board, Washington Sex Offender Policy Board, was directed by the legislature to really study this issue. The Sex Offender Policy Board has all of the interested party and stakeholders already present to take a look at this issue. And then a number of individuals involved in 7109 were permitted to participate. And so finally, I think it was not this past session, 2021, yeah, at the end, a statute came out that changed things where defenders still have a right to petition for an LRA even if the state doesn't agree. And, you know, needs to propose something. And if the Special Commitment Center can't come back with something equal to the LRA plan that has been designed by defense, then the court will consider defenses. But if the Special Commitment Center can provide them an LRA after 90 days after the petition's been filed by the defender, then both plans will be looked at. Right now, the Special Commitment Center is really struggling with housing. They have attempted to set up a secure community transitional facility in Snohomish County. They have attempted to open an adult family home in Thurston County. And what's happening is, because the statute from a year and a half ago that went into effect has limitations that say that any housing cannot be within 500 feet of a daycare center, this means even a home daycare center where there's one individual there would rule out the individual being there. And zoning, so having secure community transition facility type housing along with adult family homes, they were starting to be zoned out because that one provision in the statute allowed the counties to kind of take over, which is not what's supposed to happen. The state is supposed to have total control over this so that this doesn't happen. So the Sex Offender Policy Board is submitting another report to the legislature where all of the 7109 parties are on board with changing that provision, because otherwise there will not be able to be any type of actual housing, and housing that's not, you know, out in the boondocks. We need to have it so that the individual can have a worthwhile life. They can be out there, they can be cared for, they can access services, and they can be seen instead of being tucked away in some house that's miles and miles away from any kind of, you know, activity and things like that. So that's what the new system is. And one of the challenges that we're also finding, as I think we're finding in many areas, is that the sex offender treatment providers who provide this care in the community, they're very well experienced and gifted, so much better than what's provided on the island. But there's very few of them, and they have increasingly reached that point where they've retired, and there's not newer ones ready to fill in those holes. A lot because you have to do a lot of special licensing. It's expensive. There's a lot of hours you have to do that are not compensated for your training. And you have to be willing to deal with the headache of working with Department of Corrections, DSHS, BHA. I mean, it's a adversarial job that many SOTPs don't want to be involved in. The compensation has been raised. It's still not what you can get in the private sector. So that's become a huge issue as well. I guess how I'd like to maybe kind of bring this around is an enormous amount of work was done once we got the right defenders. And once the defenders were able to really work these cases, then you had our partner, Disability Rights Washington. And I say they are our partner because dealing with sexually violent predator issues with the legislature and the community, as you can imagine, is not popular. But through the lens that these individuals have disabilities and that they're not getting the adequate treatment and that they have a right to that and that they're just lingering out there on the island and they're not even being accommodated in any kind of way. And in fact, they're being treated, I think, in a malpractice kind of way. And everybody takes Disability Rights Washington seriously in a way that they don't take public defenders. I don't know why, but we're very happy to have them. And so they have been a huge partner in this. They monitor it. The Sex Offender Policy Board is monitoring it. And then, of course, the defense attorneys. And so I think having a group of defense attorneys who are skilled in this area and don't have enormous caseloads, working with all of the stakeholders and willing to get into the rooms. And it was hard. It's been really, really hard. It's a very emotional topic. The trauma that the victims go through, that the patients, the individuals go through, and the vicarious trauma that all of us experience being a part of this. But the individuals that are involved in this, from what I can tell, are involved in this because of what this is about and trying to get individuals that have been forgotten and making sure. And let me tell you, the individuals who are getting out, they are so at a point of easy, manageable risk that it's just not what it was like before. And so with that, now we are in 10 years into this, and the legislature has requested at the Disability Rights Washington request that has directed the Washington State Office of Public Defense to come up with a proposal for the statewide administration of public defense in the area of not guilty by reason of insanity. Specifically, the statute is named 1077, and it only has to do with once the person is committed, either by stipulation or by trial. Once they are committed under the NGRI statute, they have a right to an attorney. There's a state Supreme Court case called Fletcher that came out several years ago that talks about this. And so Disability Rights Washington noticed much of what they noticed with the 7109 population, that because of Washington State's decentralized public defense system, it's all over the map how individuals get out. And also the focus is oftentimes on, if the person is getting out, the focus seems to be on what they did 20 years ago, 10 years ago, 5 years ago, not on where they're at right now and what things can be done to help mitigate risk. There are no release plans being done except by DSHS, and they barely are able to do that. We have a highly skilled forensic social work system group that do release planning for these individuals, and they're able to find all of the necessary resources across the state. And so we've actually partnered with the SCC in many ways. And I think that's how sometimes this mental health system is going to improve, is if we go in there and show them what all the problems are and get this thing moving along with other partners. And the cost is enormous. And it's also a vestige from the 90s and early 2000s of mass incarceration and mass institutionalization. So we're now looking at this for the NGRI group, a similar program. And that's the kind of stuff that's starting to happen here in Washington State, where civil commitment, things that came out of the criminal system, much like what we're seeing in DOC, where folks who are needing to be resentenced because they were young when they were first sentenced. They have extraordinary disabilities, or they're just no longer a risk and need to be resentenced. So we're working on this, and I feel like the 7109 system now is, while it's unfortunate that we have to have it at all, it's at a point where you have an avenue out, and our attorneys and partners will help you move as quickly as you can. And I think this can now be shared with other areas of mental health. And so, yeah, that's what I have to say about how Washington civil commitment laws are like here where we're at. It's still a work in progress. But my work here for the last 10 years, I have to say I actually have a lot more hope that the system can become something at least where maybe everybody can start in the community or close to it so that they don't have to be locked up. And also to deal with the issues of people with disabilities, significant disabilities, and people of color being disproportionately impacted by this, because that's certainly the case. So I've enjoyed my time sharing my story about Washington State civil commitment law. There's lots of creative things that can be done with it. There's about 21 states that do 7109 civil commitment. And many other states have a lot of problems. And I think part of that is, well, actually, I don't know, but I don't know. It could be the partnerships that have been made. And that's really the only way, I think, when you're dealing with mental health and communities and criminal, like the forensic area, you got to work with everybody. But at other times, you got to litigate the crap out of it, because once people say, nope, absolutely not, juries have a very different take on it. They do. They don't like this law. They don't like the double jeopardy aspect. But they are also concerned about having these individuals out in the community. So there's a lot of safety and protective factors within this law now that weren't there before. I don't like it, but it does give a number of individuals who probably would never have made it out of prison under the indeterminate sentencing. It gives them a path out, and it gives them a lot of support. So thank you very much.
Well, it's been a long day of great sessions from Dr. Appelbaum through the state of Florida, California, Colorado, Washington State, and now it's time for our panel discussion with Katie Donahue, who is the city attorney in Denver, Phoebe Bell, who's the director of behavioral health services in Nevada County, California, Jonathan Cantarero, who's an attorney working for a nonprofit organization in California, and Professor Bob Borkowitz, sorry, stumbling over your name, who is at Seattle University and gave a talk just a few minutes ago. And we're here for, an hour to answer questions from the day for anyone who wants to put questions in the chat, and to talk amongst ourselves. We had a lot of interesting ideas flowing around, and a lot of unanswered questions. So welcome everyone, and thanks for coming for this live panel discussion. So if folks now have questions, either for one specific panelist or for the whole group, now's the time to put those questions in the chat. If you put them in the chat, we'll try to get them introduced into the conversation. So maybe just to kick it off, talk a little bit about outpatient treatment in California, Phoebe. And there were some people concerned in the chat, and there's a general concern, and you spoke to it quite eloquently about the boundaries of outpatient treatment and the work that you've done to respect the individual in the midst of doing the work and protecting them. And I'd like to ask you to talk a little bit more about that, and then ask Jonathan to come in and talk about the ethics of outpatient treatment.
Sure. And I think I have this discussion a lot with my peers in other counties in California, because people are absolutely mixed on both the ethics and the value of assisted outpatient treatment. And all I can say is that in our county, we've found a place for using it as one of the many strategies that we have to support people. And my experience with it is that if used correctly with the right intention by the right people, it's a really helpful tool. And for us, we really look at it in terms of what we want to avoid for people whenever we can is that highest, most invasive level of care of involuntary treatment, involuntary inpatient treatment, where somebody's lost all their rights, they've lost all their normal life, that where they want to getting to choose where they want to live and who they want to be with and what they want to do with their time, all the things that, you know, as humans, we all want for ourselves. We want to avoid that whenever we can. And so we try to use our assisted outpatient treatment program as another strategy to try when somebody is really on a trajectory that's looking like it's going to land in that conservatorship, loss of rights place. And if we try AOT, can we get connection, build rapport, and get that person engaged enough in some amount of support and services and treatment that allows them to become more stable and able to maintain their life in the community and, you know, with more control over what they're doing. And so to us, it's actually like ethically critical to try that before going to that higher level of care. And we tend to have really low numbers of people who are in inpatient longer term stays compared to other counties. And I think one of the reasons is that we have our AOT program working really well.
So, Jonathan, would you talk for a moment about your perspective of this ethical conflict, about where the boundaries begin and end? Clearly that it's a great notion for the service provider. But there's so much concern, as we heard in several of our sessions, about the misuse of civil commitment statute.
Yeah, so one thing that I've seen as I've talked about this with quite a number of people is that like at the most basic level, it seems like it boils down to the degree of the deprivation of liberties. So at one level, outpatient treatment seems like the least evasive, and then it goes into inpatient, and then you're talking about treatments over objection and things like that, where it's like just complete loss of all your rights. But having worked briefly at a separate nonprofit on Long Island here in New York, there obviously are instances of abuse, even with respect to outpatient treatment, where it can even feel more evasive than the inpatient model because there's no escaping it. There's an interesting comparison that you can make between traditional outpatient treatment with someone who, let's say, suffers from bipolar disorder, schizophrenia, and then what we're seeing more and more now, the persistent sex offender who is being civilly confined on a little bit of a different basis. So, in New York, for example, you have mental hygiene law, Article 10, which allows a civil commitment of somebody who's a persistent sex offender. The standard is a little different. It's not a mental illness and dangerousness. It's what they call a mental abnormality, which is sort of a creature of statute. It's not a medical term. It's a legal term, and it's essentially a type of mental condition tied directly to a sexual proclivity or inclination. That's where the danger comes in. That the danger is that because of this condition, it makes it likely that they will repeat those acts for which they have been criminally confined in the past. So the reason why I'm mentioning this is because there is an outpatient version of this. So someone can either be civilly confined because they're a persistent sex offender, or they could be placed on what's called SIS, which is strict and intensive supervision and treatment. The issue is during the initial commitment hearing, you can be placed in one of those two options, civil confinement or be placed on SIS. Once you're placed in civil confinement, it's almost impossible, and there's a lot of litigation in this area, to go from the most evasive to outpatient treatment. Just because someone who's dealing with that kind of abnormality, whether it hasn't been studied enough, or I'm not exactly sure what the answer is, but it's not something where they go through an episode, for example, and they can take medication, and then they can return to the community, and with support services, they can, lead, relatively normal lives. And so it's interesting because in that particular case, if they manage to be placed into strict and intensive supervision, they oftentimes go right back into the commitment. So, sometimes having the option even there maybe feels more intrusive because it seems like an endless cycle of in and out, in and out, in and out. But I guess the main point is, obviously there are potential for abuses even with respect to outpatient treatment. And in my own experience, I've heard from individuals who have received services in an outpatient setting, voice those concerns. And I think we do a disservice when we don't take those concerns seriously and try to find ways to work around it. For me, part of the answer is the type of training we're providing to the staff that are working in these facilities. That for me has always been a key issue. You can't have too much training in these areas to try to develop characteristics and skills that are supportive and not intrusive.
Yeah,
I'm sorry, go ahead.
Yeah, no, I totally agree with everything you just said, Jonathan. And I think we have to look at every aspect of the services we provide constantly to look for ways we are going too far or not, like inherently respecting the human being that we're trying to support. And absolutely, court-ordered treatment of any kind is ripe for abuse and needs to be looked at super thoughtfully and carefully. I think training is critical, not just actually for the treatment providers, but for the legal team as well. And we, in Nevada County, we had one judge doing all of our assisted outpatient treatment court for many, many years, and just switched judges recently. And that was really anxiety provoking for us, because one of the reasons that we as kind of, recovery oriented strengths-based clinicians felt okay about our AOT program is that our judge treated people so respectfully and was so clear about it is a strategy to engagement. It's not a punishment system or anything else. And so having that new judge trained and, really understanding what the goal of that court process is, has been critical in our experience. So I think, to your point, everyone in the system has to sort of share common values around how and when and why we're using this approach, and how and when and why we're not using this approach. I think for us, another reason that our program feels successful is it's deeply embedded in our existing assertive community treatment program. And so the services, the treatment itself is still grounded in ACT philosophy and approach. It's just a different doorway into that. We have a length of an order is 180 days. So it's not endless. We drop orders when they're not working. When it's, when we have somebody that is making things worse, not better, then we'll say, this isn't the strategy. Let's try something different. So I think I believe strongly there are ways to implement AOT that's aligned with the values that we hold as society for sure, but also as treatment providers. But I think absolutely cannot happen that way too.
Phoebe, do you have the ability to step down people from hospital into outpatient care?
Yeah. Yes, absolutely. So if somebody's conserved and we can bring them into community level care as well. And there's legislative change recently to AOT law that also allowed AOT to be used as a step down strategy. So a conservatorship could end and you could move somebody into an AOT status. We haven't used it in that way, but I think different counties have different kind of risk tolerance around community-based care for people who are still conserved. We're totally tolerant of that and do it often as much as we can. But somebody's still conserved.
Would you talk for a moment about some of your strategies for keeping people engaged in care, people who don't want to be engaged?
Yeah, our team, our ACT team is just super skilled. About half their staff are people with lived experience. They're really skilled at building connection and rapport with people, and they're very deeply committed to supporting people's right to choose the life they want to live. And which sounds ironic to say that they're also our AOT program provider, but they are very open-minded about what wellness and recovery can look like for somebody. And their goal and our goal with them is to provide as much different kinds of resources people might need to address the issues or needs they want to address that might be different than the issues or needs that their psychiatrist might think they need to address or whoever else. And so the team, you know, we have a lot of flexible funding associated with the program, so that can support housing when we can find it, interim type housings like hotel rooms and stuff. It can support car registration or classes or, you know, all the different kinds of things that people might be wanting to pursue. And I think that some of it as well is like really using that client-centered, you know, basic motivational interviewing and those kinds of skills to start to work with somebody around what are your wants and desires and needs, not what are the system's wants and desires, but what are yours, and then how do we meet you there and bring some resources to bear to help you get to where you want to get to. And that engagement process really works with our AOT folks alongside other folks.
Here's a question that was asked earlier in the day to the whole group, or I think everyone could make a go of it. This is terribly difficult work and not suited for everyone. How do you, what's it like to get someone to work in this field and to supervise them and to support them in doing this sort of work?
Yeah, it is so hard. And I don't think California is alone in the sort of workforce crisis we're facing right now. It is super hard work. And some of these jobs are not super well paid. And we're taking folks who aren't getting paid that well and don't necessarily have a ton of training and support and asking them to do some of the hardest work out there. And I think it's, you know, I don't have the perfect answer to this, but we work really hard to try to just recognize that with our team and to really talk through how hard it is. We work to have rituals and ways of acknowledging the loss and pain that happens when our clients die, when our peers and coworkers don't make it. That's a really important, like that pain of loss is real and rough. There's also the pain of like, I've been working through this in the last week of the amount of sort of community hate you can face doing this work, and particularly around trying to secure housing for people. That just horrific things that get said about people that we all really care about is really demoralizing, and keeping morale and energy up in the face of that is really hard. the patience of recognizing that the journey that people can be on that can have ups and downs and stops and starts, and still seeing it as a journey. It's hard work. Yeah. Sorry, I'm rambling a little, but it's just, you're spot on. It's just hard work. And I'm grateful every day for the people that continue to choose to engage in it.
Professor Bob, you represented someone that pretty much everybody in the state of Washington hated. And what do you say to students about taking on a difficult person, representing someone who they may not respect, they may not understand? And how do they get about with the work here? Can you speak a little bit about that?
Really good question. You know, for me personally, it's about the individual against the power of the state. And I don't know California law, I can't talk about that. But our law, when I was doing the work, was just outrageously unconstitutional. And even though the court upheld it, I really think it was and certainly was being implemented unconstitutionally, and in that there was no treatment. So it's kind of a step down from death penalty work in the sense that the state is really trying to crush your client. And so when you have that attitude or approach and you're representing an individual against the power of the government, I think there's a lot of ways to motivate folks. The reality is that some, as you said in the beginning, some folks simply are not going to be comfortable representing sex offenders. And they may have personal experiences that make it hard for them. And I think that's something that we have to recognize. And to the extent we're supervising lawyers or clinical staff, have to be aware of that, have to recognize that there can be traumas in someone's past that make it hard to represent someone. But for me, it was about fighting this outrageous law that wanted to punish people into the future who had already been punished and done their time and had done nothing wrong since they were sentenced. They had been told that they were done with their sentence. They'd been punished for what they did. They could start their life over, and then suddenly they couldn't. So for me, that was a main motivation. And I think for the people on my team, that was a big part of it.
If I could chime in, I agree with everything you said. And I think if anybody's interested, one documentary that I think captures that kind of mentality of maybe fighting the system is Gideon's Army. I don't know if anyone's ever seen that, but it basically follows criminal public defenders in the state of Georgia. And they make a point in that movie that, sometimes it can be difficult to find something positive in every particular client that you represent, but every case has a redeeming quality, right? So even though you may not particularly see eye to eye with a client that you're representing, whether it's civil commitment proceedings or criminal defense work, every case has a redeeming quality in the sense of, ensuring that the Constitution is upheld and fighting the system. And I just wanted to chime in also to the earlier question about, I guess, identifying staff who can do this kind of work. Having been on the side of the intern or volunteer, I know that the biggest thing was distinguishing between skill and passion. And that when it came between the two, if you're looking to recruit individuals for your particular nonprofit or your particular agency, you should always choose passion over skill, because you can teach skill. You can teach the laws, you can teach them the statute, you can teach them the procedures, but the passion is what develops that kind of mental endurance to get through it. And I'm seeing that now, even though I'm in private practice, my entire practice is representing victims of child abuse. Not everybody can do that work, and we have a really, really high turnover rate with our staff. And so that's been something that we've been working on
it's a transferable skill to be able to identify people who are passionate about a particular subject matter and go with that and trust that that passion will kind of carry them through, and that the skills will come later if they're lacking those skills at the initial stage.
Katie, thoughts about representing people who are difficult?
Well, I don't represent, but I'm acting on behalf of facilities, and it can be difficult. And I'm often torn between, there's this respondent who's in significant need of assistance to the point that they've been hospitalized. And then we have petitioners, professional people, psychiatrists and psychologists who don't recognize the severity or the substantial liberties that they're taking away from people. So we deal with difficult people. I think all of us here, we deal with doctors and we deal with lawyers, and I don't think they're known for being easy to work with. So it can get, I'm an attorney, so I'm allowed to say that. So yeah, I mean, it's tough work. And I remember someone asked me a very similar question about how do you stay in this field recently, and what makes you continue to want to do it. And I agree so much with what Phoebe was saying, and it is hard work, and it's hard to say why we keep doing it. And it's just an innate passion, I guess.
We have a question from the chat, and I think this is a good question, Katie, for you. And maybe it's an imaginary question, which is, what about a petition for civil commitment that if the criteria for inpatient civil commitment is not met, that there be a second sort of level of service for outpatient, sort of two different criteria. Would that be possible to do a multi-purpose petition?
So Colorado only has the one system, and our system is a blend of inpatient and outpatient. I think what you just described was essentially what some states have with, I guess California calls it a conservatorship, plus the court-ordered outpatient treatment, the AOT. Colorado doesn't have that. And one of the things that I, in conjunction with these amazing facilities that I work with, try to create is a way that someone can be placed under a certification and almost immediately go to outpatient treatment. Basically, we do a lot of working with what we have to do right by our respondents. So, it's really interesting to learn about all the other states and how they have these different levels of treatment, but we just have one level, and they can be inpatient, outpatient. We have a lot of people who are under certification, under court-ordered meds, that are living in an independent housing. And it's but for the court order for treatment that they're able to maintain that. And eventually those certifications get dropped. But, I think a lot of states are doing that already with the tiers of criteria required for inpatient, which I think we heard a lot of, is that imminent danger to self, imminent danger to others, and then sort of the outpatient where we're looking at grave disability and maybe lesser danger to self or others.
Comments from Bob or John?
Just from an ethical perspective, I think it's interesting that the default is the petition for civil confinement, and then it can segue into outpatient. I understand it, obviously because of the imminence requirement, but it's just interesting that was our society's initial model, and we've just gone with it rather than using maybe a least restrictive means approach that you see. I'm using an analogy from family court now, where we start with the least restrictive, and if we see that it's not working, you work your way towards commitment. I'm just theorizing now, but that's just an idea that popped in my head based on what Kate mentioned.
Our civil commitment laws, both regular ones and these, do provide for an alternative to the petition being found. So less restrictive alternatives are possible.
Well, next question, and this question comes, I think, at the end of almost every conference day in the mental health world. If you had a sack of cash, a big sack of cash, let's say $10 million, how would you, in your mental health system, in your service system, what would you do? King for the day, queen for the day.
I don't know if 10 million's enough in Denver anymore.
Not that much anymore, huh?
We need housing. I think we need supportive housing more than anything else. I'm a housing first kind of gal.
Jonathan or Bob?
I would just say supportive services. So, I mean, you see this across the nonprofit world, but particularly, you know, I was working briefly for Nassau Suffolk Legal Service Committee, which covers Long Island, 2 counties in New York, and they have a mental health unit. And just the amount of people that are calling in requesting services, there's not enough attorneys to handle it, regardless of, you know, regardless of the willingness. And we have, you know, they have a robust kind of volunteer staff and volunteer pro bono program and all of that. But it just doesn't seem to be sufficient. And so I have very vivid memories of my time there of literally not being able to take all the calls of people calling in just because of the lack of resources. So yeah, 10 million is definitely not enough. Maybe 10 million per county would be more realistic, but supportive services, housing is obviously one of them. But legal services, there are so many areas of need. Once somebody is released from an institution or a hospital or whatever the case may be. So it's really hard to pinpoint one. It's kind of caught under that umbrella term, you know, applying for government benefits, you know, you need an attorney for that, et cetera. So all those support services is where I would direct those resources.
A couple of years ago, when Portland was starting to get serious about fixing homelessness, we invited the folks from Los Angeles County to come up here and tell us how they were doing it. And they said, well, the real problem here is you guys got to get used to the B word, the billion word. Everyone shut down in the room. It was the end of the day.
Yeah.
Now, 2-3 years later, we're deep in the B word. I don't know if everyone got a chance to see, but Professor Cohen this morning gave a talk on the sort of fundamental lack of data around civil commitment. And Cohen says that we just really don't know anything about the dimensions of this problem, where people go, what happens to them, how many people flow through this system. He says that other than just little pieces and parts of the service system all over the country, we have no idea. Did anybody have any thoughts about how do we go about fixing or redesigning something? We don't know any of and we've been redesigning this forever. How do we go about redesigning this without actually knowing what it is?
So my first thoughts I only saw part of the presentation, but it was very insightful. My first thoughts, again, just putting that ethical hat on, is that you have to be very careful about the method that you employ to make sure it doesn't further traumatize the people that you're trying to serve, because it can be very intrusive. You know, I was just thinking about an analogy to like COVID tracking, when you would have people call you and just to find out, you know, who you contacted, you know, where you've been, that kind of thing. And you can easily see how trying to track, you know, where someone goes after they're released from a facility can become extremely intrusive on them. You know, they're finally released and now they're getting calls all the time, asking them, you know, basically like an interrogation. So that was my first thought. I think it is extremely important because it never occurred to me that we don't really know anything. But at the same time, we shouldn't seek out data at the expense of honoring the autonomy of individuals who have made enough progress to kind of return to their day-to-day lives.
Mm. Mm. Any other thoughts on Professor Cohen's work? Well, let's move on to an area which I thought was really interesting and sort of a theme running through this conference is the sort of the edge of civil commitment, the non-typical mental health edge of civil commitment. And we heard in Denver that they're using civil commitment for people who have eating disorders. And we've heard in Washington State that indeterminate sentencing has been used for people who may commit crimes in the future of various sorts. And we heard also about a little chat this morning about the use of civil commitment for addicts and alcoholics. Some people we know that incarceration, institutionalization does not benefit the socializing aspects of their recovery. Jonathan, where do we, I mean, you made it so clear this morning, but I guess I'd like you to make it clear again in new words, is talking about the purposefulness of these laws. Why do we get to this point where we try to use them for other purposes?
Yeah, that's a loaded question. I will say that it's even worse than that, because when the government cannot find a way to categorize a certain group into the existing statute, they'll just create another statute. And that's what you see in all the persistent sex offender laws. Imminency isn't really there, even though it's kind of a component of dangerousness, because the expectation is that they'll commit a sex crime a year from now, 5 years from now, 10 years from now, when their history shows, maybe they have 3 sex convictions that are 20 years apart, or 10 years apart. So it's almost worse than what you mentioned. With respect to the eating disorders, that's really interesting. So I wanted to share this anecdote of, and it was something that was running through the chat, as well as in terms of these chronic illnesses that affect the individual's health, and where's the line for that and civil commitment. And so I remember several years ago as a law student observing an initial hearing where a daughter had petitioned for their father to be civilly confined. And at the hearing, the only testimony of anything, the basic argument for civil commitment was, well, he's not taking his blood pressure medication. And the daughter thought that was sufficient to deprive him of his liberty. Basically, he can keep him there indefinitely. So the judge, looked at the daughter square in the face and said, the government is not here to tell your father to take their blood pressure medication. We can't force someone to take their blood pressure medication. So that's one end of the extreme, right? But then you start chipping away and looking at other examples of, anorexia. A lot of times, and I don't know, I guess one thing that I'll say is that it's a very fact-specific inquiry, because a lot of times when you're dealing with issues or conditions like anorexia, it's usually tied to another issue as well. Depression, right, is a big one. And so I don't want to create a problem when it's not there. And I guess based on your answer, there are situations when someone is literally being confined solely based on anorexia. But I would suspect that in more cases than not, it's usually anorexia plus something else. And so, for example, in the persistent sex offender context, the way that the government is able to petition for civil commitment, they have to have a showing of mental abnormality. The showing of mental abnormality usually requires the establishment of some sort of mental condition. And for anyone who knows anything about the criminal justice system, roughly 90% of people who are incarcerated suffer from ASPD, antisocial personality disorder. initially they were using just that one diagnosis to justify the civil commitment. Eventually that was struck down by the highest court in New York, the Court of Appeals. And now it requires, in addition to ASPD, some other form, some other mental condition that together meets the standard for what they consider a mental abnormality. And so I guess, a little bit of a cop-out, but I think it's a very fact-specific inquiry, because it's usually not just anorexia or not just bulimia, not even just depression, but depression and suicidal ideation, right? The dangerousness to self. And so you have to look at it on a case-by-case basis.
Now, I want to note that we're all lawyers in the room now. So here we are talking about mental illness, but I want to ask, Shoshana, is antisocial personality disorder something you can treat?
I think everybody's treatable. I mean, in some way, you just
I've been watching
out...
Donald Trump for the past 4 years. I don't know.
Except a malignant narcissistic disorder. I hear that is not treatable. Well, it's interesting because the antisocial personality disorder, there's not a case in Washington State, but there must be enough peer review articles or whatever that I think the experts all sort of agree that you can't just have ASPD only. Anyway, antisocial personality disorder, yeah, sometimes that means you're young, and you haven't kind of gotten out of that phase, and not being able to really kind of see or feel the consequences in such a way. So yeah, I guess that would be my response, is that for the most part, it's finding the right type of treatment, and that, if you're really looking at the individual, then you kind of just, you do it based on what is going to work for them. To see kind of how they're feeling or thinking, at least they know if it's somebody with just ASPD only or something like that. I don't know. I kind of feel like there's many reasons for how they arrived at that and who they are. I mean, the people that we see in the juvenile offender world or the adult felony world, they have stories about, you can see how it would arrive at ASPD. So, yeah.
And Katie, let's come back to you with the eating disorders. Tell us a little bit about this program. When I heard about it, I said, oh my gosh, we need that here. We need that everywhere. And then I started thinking about it, and it is just, it really stresses the idea of this civil commitment statute.
Yeah, I mean, in response to what Jonathan said, we actually do have cases that are focused just on anorexia alone. What's unique about Denver is that we have the only, and I could be misstating this, but I've been told this from testimony under oath, that is the only medical stabilization unit for eating disorders in the country. So the individuals coming through this are at single-digit BMIs. They're at risk of death at basically any moment. They're at risk of death for eating too much, too fast. And as I stated earlier, I think Colorado has a broader definition of mental illness, and starting to learn about the other states. Some are limited to psychotic, and I can also address the substance abuse thing. But all that's required is a substantial disorder of your cognitive, volitional, and emotional capacities that interfere with your judgment, interfere with your ability to control your behaviors, and interfere with your ability to control your behaviors. And when we're looking at or interfering with your ability to recognize reality, and when we're seeing eating disorders that reach the level that their cases coming across my desk, their thinking is distorted with respect to body image. Their thinking is distorted almost to the point of psychosis in that they believe that they can eat and survive on 600 calories or less a day. It's always a hard case to prove. And a lot of these individuals are extremely high achieving and they've achieved great things. We've had people in medical school, we've had people who are doctors, people in law school, PhDs, and we really make sure, as I said earlier, we really want to make sure our cases are meeting the constitutional requirements. So we spend an extensive amount of time talking to the doctors about how someone can be so substantially distorted in one area and so rational in another. And, you know, I walked into this program and the certifications for eating disorders already existed. And I do think it's right. I do think we saved lives. So I know it's a contentious issue and not everyone's going to agree with it, but I do think that we've saved lives and we've also seen people pass away. It's really difficult. And I don't know if we want to get to substance use disorders.
We do.
Okay. So my opinion on that is in Colorado, I heard, I cannot remember which presenter it was, but that only 2 states utilized, we actually call them involuntary commitments for substance use disorders, which includes substance and alcohol. And, you know, it's difficult because when you have different statutes, someone was saying if they don't fit this criteria, just make another statute. By doing that, we're creating silos. And I think we really lose sight of the fact that people experiencing mental health issues, people experiencing substance use disorders, people experiencing trauma, they're all the same people. So forcing someone to go through statute A because it's for mental health, but not get treatment for substance use because that's under statute B is a little ridiculous and outdated in my opinion. But we do see that. And in Colorado, if you have a mental illness that is interfering with your ability that you can't benefit from substance use disorder, you can qualify for an involuntary commitment. And I will say, I know people are probably very afraid. For substance use, it's a 30 to 45 day inpatient, and then it graduates down. So most of the time under an involuntary commitment, you're an outpatient receiving intensive outpatient or regular outpatient treatment.
Does this also serve the fact that the insured sector doesn't provide these services?
Absolutely. We see issues with insurance a lot of times. And one of the really harsh realities that I've learned is for the substance use commitments, the respondents end up having to pay for that. They have to pay for involuntary care. We are lucky enough that we work with it's a statewide agency for substance use. I think it's non-governmental that gives scholarships to people under involuntary commitments, but I really struggle with that myself.
So we confine you, then we bill you, then we give you a scholarship to pay the bill to alleviate our conscience about confining you. Okay.
I agree. Okay. It's not great.
Jonathan, you're our ethicist. What do you make of that?
Yeah, that's like new to me. I don't have any specific comments about that one.
You know, I think one of the answers to your earlier question about why do we have all these statutes, we're expecting the legal system, particularly the criminal legal system and increasingly the civil commitment system, to resolve the problems of the rest of society for not funding treatment and education and housing. Most of these clients, if they had decent housing, mental health treatment when they were young, good education, a place to live, they would be presenting far fewer problems. And that's true whether it's the criminal legal system or the civil commitment system. And I just think it's the back end rather than the front end improving the education system and making sure there's decent mental health treatment for kids, because so many of the clients that we have in, as Shoshana was saying, in the adult criminal world and juvenile criminal world, their traumas that they have personally faced, their ACEs score, are out of sight. Parents shooting each other, parents in prison, all kinds of problems. And what do we expect is going to happen when we don't take care of that at the front end?
Yeah, it is kind of alarming that we turn to the legal system, not just you attorneys, but also the cops of all people, to fix our mental health system. It's quite, and they resent it too. It really is the most expensive and just about least effective response to mental illness. Is there any way out of this to get you guys loose from this problem and get it back in the hands of the people?
Yeah, I think that law enforcement is left to deal with a lot of these. They're the initiators of most mental health holds, and from what I'm familiar with in Colorado, and I'm sure elsewhere, they're responding to crisis, whether it's a violent crisis or a mental health crisis. And it really puts a strain, and we expect officers who receive maybe 40 hours of CIT training to make a decision in the community that this person is gravely disabled or a danger to self or danger to others. And I do want to point out, in Colorado, in Denver, we have amazing programs. Obviously not enough, but one of the programs that started it's called the STAR. And when people call 911, and I don't know if this was discussed at last year's conference, but when people call 911, we either have a co-responder go out, which is law enforcement and a mental health provider, or the STAR van, which is strictly mental health providers. And I think that, in my opinion, my personal opinion, is the direction we need to lead in or go in. But at the same time, I understand that there's, liability and concerns about a treatment provider, a mental health clinician who has certain codes of ethics, putting hands on someone and bringing them into a hospital, if that's what needs to be done. So I don't know, maybe we need a licensed mental health force sometime in the future to deal with this. Or I really agree with Bob on, society as a whole just needs to be more supportive of people from the outset.
The Denver STAR program was the star of our conference this spring on alternatives to police. We do have these cropping up all over the country in response to sort of people thinking, hey, and the cops also saying, hey, we are not the right people to do this work. Shoshana, you got to hear Bob's recording before you made yours, so you had a little bit of an advantage there. Do you want to talk a little bit about how things the segue between the two? As Bob is leaving the court, just troubles, and you come along a few years later to defend these folks from the state's, you're working for the state. You want to talk a little bit about that transition?
Yeah, it's kind of interesting because, it was, trying to think, I was running, I was actually the program director of the Sex Offender Policy Board at the time. And before, I think it was like in 2011, they were starting to talk about the 7109 population, because what was happening is we were starting to get word that, research was changing about risk, age, whose risk, but also, and that folks were at the point where they were ready to be released. And nobody wanted to talk about it. So, because the way that the civil commitment law, 7109 civil commitment law was billed, at least in the beginning, was that this was just a way that we can get individuals who don't have like life sentences put away. I mean, it really was that kind of law. Like, this is so screwed up. But the science was there. It had been several decades that the law had been around, so people were ready to get out. And it was anyway. So the Sex Offender Policy Board was about to start looking into this and do a deep dive about where the science was and what was going on. And then the Great Recession happened, and things like that, like boards and commissions were, they kind of went dormant. And then several years later, when things were kind of back up, there was all this, what was the deal? There's all this concern by the prosecutors and the AGs and I don't know who else, that the defense system before we came along was becoming a cottage industry, and that the defenders, it was all on the defenders. The defenders were billing hourly just to sit and read whatever, and that the experts, they were hired guns. And I mean, it was really kind of ridiculous, but they were successful. And so some limits were put in about how many evaluations you could have, the cost of it, things like that. And then my office came in and they wanted us to contract with all the attorneys and agencies that provided this work. So that, and what happened is we went from hourly to contract hourly amount. But so that was the beginning of that. But what was also happening at the same time is the research was really coming back strong. And the indeterminate sentencing, the persistent offender law for the sex offenders back in 2002, a lot of the people they were filing on back in the day are the people that those laws took out. And so normally I think the individuals that they were seeing that were going to maybe be released, they were less that type of, long-term DOC time and more about individuals with all different types of mental health and disabilities. So it actually sort of became more of what you'd think of the civil commitment statute. I'm not saying all of it. So I think it was the research, the science, the expertise in representation that kind of really shifted this into, okay, well, now we have to actually, since there have been cases and Disability Rights Washington was involved in saying, like, remember, this is not a warehousing thing. This is supposed to be treatment, even though they have to be reminded. And so that's how I think the whole thing is. The population changed a little bit and the science changed, and the legislature paid attention because their constituents were upset. So the issue being forced, I mean, I know it's weird, but the issue being forced in some respect is how we kind of got into this whole statutory amendment process. And it's a fight, but I think because how folks are framing the issue now, it's less about what that 1990s, early 2000s, the predator, and more about, I don't know, misfits who you see a lot of folks with juvenile background, like foster care stuff and traumatic brain injuries. And, it's kind of one of those all along, like they didn't get the treatment they needed as a kid. They were in foster care, all of these traumatic things that happen. They didn't get any kind of treatment in the 20 to 30 years that they spent in prison. And so then they move on to the civil commitment process, which now, because you have an avenue out, allows you to actually kind of deal with that. But it's awful. I mean, since a lot of these people, since they've been like 5 years old. And the attitude, I mean, it's weird. It's like we have the attitude in the world that we need to bring down mass incarceration, bring people into the community. But when it's really happening, it's a lot more conservative perspective. So, you know, it's like walking a tightrope. You just got to have, and I think that's what I've seen so far in these presentations is you got to have the skill and you've got to understand mental health and how it works. And you've got to be able to work with individuals and know how to access the system. And, you know, a lot of that kind of comes from who you are as an individual. And like what Jonathan was saying, you can learn it, you can learn the skills, but how are you with these clients and with the process? And are you willing to like go to the mat to kind of, because everything I think you do in this particular area is always going to be changing the system. Because it's such a constitutionally frail foundation. But I kind of feel like these civil commitment things that are becoming like spin-offs, it's allowing DOC, it's allowing that system to not have to treat what they really should be treating, and then pushing them off into civil commitment things, and then hoping that the legal system has an answer to getting these people out. So that's my answer.
My response is yikes. Yikes. And I'm afraid we're going to have to leave it there. Thank you, everyone, for participating in our live panel. We'll reconvene tomorrow at 9 o'clock Pacific time. We'll thank you, Katie. Fascinating conversation about what Denver's doing and your perspective on helping folks in getting through this process. And Bob, your experience at the Supreme Court and with the Washington Supreme Court, really amazing. Thank you for your work. Thank you for coming back and talking about the hard case. And Jonathan, thanks for, didn't expect to have a Kantian ethics seminar this morning, but it was really helpful in framing up the whole day and maybe the whole conference. And Shoshana, thank you for your work in defending people in this crazy system in Washington State. Stay tuned, folks. We'll be back in just one moment with the Oregon Advocacy Awards and the winner of this year's award, Angela Kimball.
Welcome, Angela, and everyone attending this year's conference. I'm very honored to be part of the presentation for Angela Kimball receiving the 2022 Oregon Advocate of the Year. My name is Bill Bushka, and I've known Angela and worked with her in different capacity since I think the late 1990s. And I had the opportunity to get to know Angela when she was a mother who was concerned about the services that her son was receiving at a children's mental health program. And luckily, I had a strong family involvement mentor. So I was well informed enough to listen and partner with Angela and listen to her concerns about the program. And they were really good concerns, and she was concerned not only about the care her son was receiving and her involvement in the services, but she was also concerned about the program overall, and was really conscious about, I want this program to be better for kids and families that come after. And it was a really unique situation. Ordinarily, as someone who worked for the state and a state regulator, when there's a problem, you do a corrective action and you require all kinds of things of the program. Well, what we decided to require at that time was not only did they have to meet with me and give me documents, but Angela was part of those meetings too. So that was pretty good punishment for the program. They not only had to meet with the state regulator, Angela was in the room also, and that really kept them going on a very good path. So as I got to know Angela and through that work, really quickly pulled her into state level work because of her ability to see problems and see solutions in different ways. And when Jason asked me to be part of this presentation, the words that immediately came to my mind about Angela were persistence and determination. But she does it with compassion and grace, which are really amazing qualities for an advocate and for someone who does the work that Angela has dedicated her life to. When I asked other people that I've known and that I know have known Angela for a very long time, one person used a quote from Bayard Rustin, and that quote, and he was a key advisor to Martin Luther King. He used the quote, and I think this fits Angela very well: angelic troublemaker. And other words that I got from people was that she's extremely effective at getting things done. She's well-spoken, ethical, and an important advocate for those who have yet to find their voice. And I further took advantage of Angela's skill and bring her into some key initiatives that we did at the state that really fundamentally changed the role of family and youth in the children's mental health system at that time. And she co-chaired the first Children's System Advisory Council that we had with a really traditional mental health provider, and did a great job co-chairing that. I think that was the first time that we had a family provider co-chair of a state meeting. And through that work, she fundamentally cemented youth and family involvement in Oregon. I then had further opportunity to work with her when she worked for the state as innovator agent, as we were rolling out the coordinated care model and the CCO model throughout the state. And I was honored to work with her in that capacity for a very long time. So knowing Angela since the late 90s, I'm proud to call her a friend, a mentor, and a colleague. And she is well deserving of this award, and it's long overdue. Thank you very much for letting me be part of this presentation, and congratulations, Angela.
Hi, I'm Bob Jundeff, former director of Disability Rights Oregon and a longtime advocate for safe and respectful mental health supports and services. Imagine a world in which the Oregon legislature decided to stop coverage for behavioral health treatment under the Oregon Health Plan, where Oregon insurance companies were free to discriminate against behavioral health services in terms of payment rates for services and total amount of coverage, and where some insurers could choose not to cover behavioral health at all. That world didn't require much imagination if you lived in Oregon 20 years ago and needed mental health services for yourself, a family member, a friend, or, well, anyone. Well, Angela Kimball has an imagination. She can envision a state in which the Oregon Health Plan was true to its name, covering health needs above the neck. She saw a state in which health insurers covered all health needs equally without discrimination in amount, scope, or duration. With skills that included rock-solid knowledge of mental health issues and the legislative process, she communicated the facts with clear and concise confidence and made policymakers feel the impact that these injustices had on human lives. Her leadership got results. Angela has gone on, of course, to apply her passion and talent for the benefit of people around the country, and we are all the better for it. While the struggle continues and lives are on the line, we stay united when we remember the victories we have won, the lives those victories have transformed, and the advocates who have been with us all the way. And so congratulations, Angela, for this highly deserved honor.
Hi, everyone. Hi, Angela. My name is Becky Child, and I'm a professor of social work at Utica College. And I have been a friend of Angela's for many, many years. We got our start working together in advocacy. She worked primarily in the kids system. I worked in the adult system, but I found her to be an incredible friend and supportive of the work that I was doing in the adult system. I remember one of the people that I started working with her about and was so upset because of her situation. And I remember talking to Angela, and she helped calm me down so that other people could hear what I had to say, because I was so upset with what they had done to this person. And she's helped me with my advocacy at Oregon State Hospital, helping me write letters in ways that people can hear what I have to say and not turn it off just because I'm pissed off. And Angela and I have always had the ultimate goal of designing a better mental health system, one that can support families and people in their time of need. And Angela, unfortunately, lost her son, and the mental health system was not able to provide meet his needs when he needed it. I know that Alex is proud of you, Angela, and the work that you do. And I just want to say how honored I am to be your friend and to have shared this journey with you. I really missed you being here in Oregon, but I'm so glad you're in Washington, D.C. doing the work that you're doing. And I wish you continued success, and I hope that we can work together again in the future. And I will see you soon in the future. Bye-bye.
Thank you, everyone. I'm Angela Kimball. I'm the Senior Vice President of Advocacy and Policy at Inseparable, which is a new nonprofit that is dedicated to improving access to mental health care for everyone in this country. And I want to thank the Law and Mental Health Conference so much for this award. It's particularly meaningful to me because of the people associated with this who really started me on this journey many, many years ago in terms of being a mental health advocate. Bill Bushka, Becky Child, Bob Jundeff, Jason Renaud, everybody, and so many others throughout Oregon and around the country have really inspired me on this journey. And it really has been a lengthy journey about trying to improve how our country delivers mental health care, and really fundamentally thinking about the fact that we still discriminate against people with mental health conditions, and we marginalize people, and there are really horrific conditions under which people live. And this is something that we all need to be devoting time and energy to. I was telling Jason earlier, though, that I am really enthused and hopeful because I feel like the country is now starting to recognize mental health as something that's important for everybody. It is no longer spoken about as something that happens to other people, but not them. And I think that is a really key inroad that has been made because once you other people, you excuse doing terrible things to them. Now that mental health, particularly with the pandemic, has been brought home to the lives of so many people, and they recognize that in themselves, in their kids, we have a new opening to actually really change how this country treats people who have mental health conditions. And what I'm particularly proud of the work of the Law and Mental Health Conference for is really tackling some of the thorniest issues, and that is people who are in crisis and how we respond to those who have symptoms that are often very troubling to other people. And to me, some of the most heartbreaking stories are those that live in my heart about people who've been harmed in encounters with law enforcement because they were in crisis, or sometimes simply because they were living and just getting in the way in other people's perceptions. I think there's enormous energy around changing that dynamic and providing alternatives that are really at their core about providing respect and dignity for everybody who lives with a mental health condition. And fundamentally, that's something that we all want in this world, respect and dignity. And that really needs to shape how we look at every single law, how we look at the data we collect, and what we fund. So I'll pause there and just say it's been a fascinating journey. I have learned from so many people along the way. There's so much further to go, but I am honestly very hopeful about where we're all headed, and we're in it together.